gonna backtrack. And you should've kept my name out your mouth. That's though how it all turned out. When you try to use my name for clout, keep on going, give me something you can talk about. Throwing all the good vibes out the window. Somebody come hold my cup, please. A squirrel is acting up. Seriously though, do you think it's a medical condition? Maybe it's demons, I really don't know. She acting up. They ain't right. Hello, everybody. We are live. How are you doing this fine Friday, April 3rd, 2026? I am doing quite well. If you just came from over at my other channel, welcome, welcome. I did make a video that's kind of like a TLDR of this one. Pretty much like going over, there were 13 claims outstanding against Justin Baldoni and, the Wayfarer parties. The judge yesterday dismissed 10. Yes, you heard that right. 10 of the claims out of 13. So I did just premiere a video on my other channel, ThatSurpriseWitness, about it. And it was like maybe 25 minutes long. And it was really just the sort of high points. But I did that with it in mind that I wanted to go over. Obviously, it's 154 pages long or whatever, 152. I can't go over every single word. But I do definitely want to go over this document today. And that would be the filing. It was entered into the docket yesterday. So come in. Make sure you hit the like. Thank you. So yesterday there was a hearing scheduled for the Blake Lively Justin Baldoni lawsuit, and the hearing was scheduled for later in the afternoon actually. And the judge, like 30 minutes, he's funny, like 30 minutes before the hearing, he drops this 152-page order. And I strongly believe that he did that because he probably didn't just finish it. I think he probably wanted to avoid the obvious inevitable, which is going to be a flurry of filings and motions and lawyer fees. Oh my. I just had the thought, I need to write this down. Somebody remind me later in the live. I need to look up, does New York have an anti-slap law? Does New York have anti-slap law, or did it at the time, like as of 12/2024? Okay, I don't want to get too sidetracked, but that's like a little ADD hack. I don't know. I'm me personally, I'm trying to like not claim diagnoses anymore, but writing stuff down so you don't get too sidetracked. Just I'm getting sidetracked. But okay, so anyway, listen. There was 13 claims remaining outstanding. Now, this is after the judge has already dismissed several claims and suits against these people in different sides of the lawsuit. Like you might recall, originally Blake Lively had sued also the New York Times. Well, that was dismissed. The judge dismissed the New York Times one for its own reasons. I believe it was because like of some type of privilege about reporter's privilege, something. I don't know. I don't exactly remember, and I don't want to misspeak, but that was dismissed, already. And then Justin Baldoni had countersued Blake Lively for various things, and all his claims got dismissed. And so yesterday, the judge pretty much, it's being called gutted Blake Lively's claims against Justin Baldoni. Now, when I say Justin Baldoni, like against Justin Baldoni, I mean all the parties. So all the defendants rather. Let me just pull up the document here so you can see what I'm working off of. This is the opinion and order. It is 152 pages long. This is like the 1273rd document filed in this case. Just for reference, Diddy's case, which did have a lot of filings in it, that one had in the 700 range. Okay, so this hasn't even gone to trial yet, and it's like nearing double that. So there's been a lot of filings in this case. Blake Lively is the plaintiff. And these were all the parties that she was suing. Okay, so I have crossed out with a little red. If you are colorblind, the color is not important. I've crossed it out with a line. You should be able to still see the line in some color, girl. But I crossed out with the line the ones that are no longer facing any claims of their own. So, for example, Justin Baldoni, I crossed him out because all the claims against Justin Baldoni have now fallen away, including harassment as an employer. Jamie Heath, similarly, his name is crossed out because he is not facing any more. The case has been dismissed against him. Steve Sarowitz, case dismissed against him. Melissa Nathan, case dismissed against her. Jennifer A. Bell, case dismissed against her. Okay, so I have highlighted in blue, or if you're colorblind, they only give you so many colors for the colorblind people, so I do have like a pre-existing color coding system from when I was in law school. So I do still just use this, but I do actually feel for the people that are red, green, colorblind, because a lot of things that they put in these built-ins are like red and green. But anyway, listen, the ones that have a block of color around them, it may look gray to you. It may appear another color, but those are the ones that are still in. They're still on the hook, as they might say. Okay, so that would be Wayfarer Studios, the LLC that they started to, I guess, make the movie. I don't know if this is the production company. It Ends With Us Movie LLC, and the agency group PR. That is TAG. Okay, so what I first of all out the gate found interesting, just based on only that, it's kind of ironic. Because if you think about it like this, okay, Blake Lively is suing, who's she really mad at? Justin Baldoni and Jamie Heath, really, right? I mean, she's mad at everybody else, but really, I mean, this all stems from like disputes against Justin and Jamie Heath. But she's, brought in these other folks from the, TAG agency. Also, earlier, I neglected to mention, I should say I forgot to mention, Jed Wallace. Remember him from Street Relations? Or Jed Wallace, the claims against him have also been dropped. And the claims against him were not dropped, dismissed rather, by the judge. And the reason why is because Jed Wallace, the judge didn't have personal jurisdiction over Jed Wallace and Street Relations. There was some things to do with, maybe stuff was filed here in this state when it should have been in another state, maybe Texas, etc. But now here we are, the case was filed in 2024. We are in 2026 and they still haven't gone to trial yet. Now the trial is set to start next month, but I have a feeling that they might settle. They might settle this case because there's a pretty strong chance that there's only really going to be 2 claims to go to trial on. Now, claims have gone to trial for one claim. I mean, cases have gone to trial for one claim, but I have a feeling that this is going to be perhaps settled. We'll see. Because sometimes people don't settle because they, their egos are involved, or they just really want to go to trial for some reason or another. And this is, in the universe of people that they have enough money. They want to, get their side out. They want to, keep running the PR, whatever the case may be. They might still go to trial. Ryan Reynolds and his wife are bitter about this. I don't know, but it does seem like they probably would be. So again, like I'm saying, right? So the people, or actually, no people, I was going to say the people that the lawsuit is still outstanding against, and then I was going to, finish the sentence, but there are no individuals left. The only defendants left in the lawsuit at all are all businesses, corporations, whatever you want, limited liability companies. All of them are LLCs. And there's 3. Number 1, Wayfarer. Number 2, It Ends With Us Movie LLC. And number 3, the agency group PR. But what I find so interesting about this is that the agency group PR, which is known as TAG, this is Melissa Nathan's company that she owns. It's a PR firm that Justin Baldoni contracted or hired to do some PR. And that is the same PR that Blake Lively is now calling a smear campaign. So this smear campaign was really kind of aided and abetted, according to Blake Lively, by the agency group, which is owned by Melissa Nathan. But it's so interesting. Like Jamie Heath and Justin Baldoni got off the hook personally and individually from this. The S harassment claims have completely fallen away. And yet, Tag, the agency group PR, Melissa Nathan's company, is still on the hook, at least for now. Now, like I said, they have the highest likelihood of actually being able to get the claims dismissed. The judge did dismiss the claim, did keep the claims against them, but did so with prejudice and, without prejudice. The judge kept the claims in, but is basically giving them another chance to get off the hook. And that's only as it applies to Tag, the agency group PR. So while it is the case that they may still get off, they may still be able to get off the hook, it's very interesting to me that the agency group is still defendant in this case. There were 13 cases. There were 10 or whatever defendants all across jurisdictions. We're in Texas, we're in California, we're in New Jersey, we're in New York, and the S harassment claims fall away. The defamation claims fall away. The conspiracy claims fall away. Half of the contracts claims fall away. But Tag is still a defendant as of now. Now, I think this would be a good time to remind y'all of the web. I actually have an entire web just for the Blake Lively, Justin Baldoni universe right here. So all these different, not all, but a lot of these different parties surrounding here were mentioned or were sued or were doing the suing. And I want to bring your attention to something at the beginning of this live, because it's going to be several hours from now where I'm going to remind you of this. Okay. So just put a pin in this, right? All right. What I'm about to tell you. So just to give you a lay of the land, here's Blake Lively and Ryan Reynolds. That's her husband. This lawsuit was initiated basically New Year's Eve, 2024. And these were all the parties that originally were sued. This is Wayfarer, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us movie, Melissa Nathan, the agency group, Jennifer A. Bell. Now, at some point, I think she tried to add Jed Wallace, but he got, the one against him got dismissed. Anything against him got dismissed in this jurisdiction. So there's Justin Baldoni, there's Wayfarer, that's one of the defendants. And then there is Jamie Heath. So all three of these were defendants in the lawsuit. But now, actually, let's see if I can put what do we have, yeah. Let's do an X over Justin. I'm going to put X's over the people who are no longer defendants in the case, just as a visual aid. Okay, so Jamie Heath, no longer a defendant. Wayfarer is still a defendant. Okay. Melissa Nathan, no longer a defendant, but you know which is still a defendant? That is her company, the agency group. So that's still a defendant, but Melissa Nathan herself, no longer a defendant. I'm trying to put this somewhere where you can okay. All right. So I want to just bring something to your attention here. This is confusing because I want it to be by Melissa Nathan, but Tag is so close to her. So I'm just going to, hold on. People ask me all the time, what is this program? This is, I'll put it right here. This is, what's it called? Freeform, and it's on all Apple products. So you probably have it if you have it. Okay. And then, Jed Wallace, we're going to talk more about him later, but part of this lawsuit has to do with Melissa Nathan, who owns the agency group PR, using her connections to run a smear campaign, a supposed smear campaign. This is just an excerpt from Blake Lively's complaint. Actually, no, this is an excerpt from Stephanie Jones, which is another PR lady. She's over here. She used to work for Justin Baldoni. Then she switched teams and now she's working with, or she appeared to work with Blake and Ryan to get text messages off of Jennifer Abel's phone. There's all kind of drama going on. But anyway, so this Melissa Nathan girl, she's been dismissed from the lawsuit, but her company, the agency group, has not. Here's an excerpt from a lawsuit that Stephanie Jones had filed. Baldoni produced, directed, and co-starred in the film It Ends With Us. In connection with the film's release in August 2024, Baldoni began to fear that the media might report on allegations of misogynistic and toxic on-set behavior. So this is in Stephanie Jones's lawsuit against Justin Baldoni, so it's from her perspective. Justin began to fear about fallout and it would be harmful to his reputation. He was determined to protect his reputation. Jamie, Heath, Wayfarer turned to Jennifer Abel, who had become the point person at Stephanie Jones, Jones Works PR for Justin, and on the Baldoni and the Wayfarer accounts. So Jennifer Abel brought on another crisis fixer for Justin Baldoni, and that was this woman, Melissa Nathan. Melissa Nathan was brought on by Jennifer Abel to help them all manage the situation. And together, Jennifer from Jones Works, Melissa from Tag, and Jamie Heath all worked together and, quote, this is me quoting from a lawsuit, conspired to shut Jones, that's Stephanie Jones, out of the PR crisis management process and to keep their strategy hidden from her. Okay, so this is all complaints that Stephanie Jones has against Justin Baldoni, but this is kind of like them saying, how did Melissa Nathan get brought on? According to Stephanie Jones, it was from this one right here, Jennifer Abel. Okay, so y'all already knew this, but Jones Works had hired Jennifer, but Jennifer was the point person with Justin and Wayfarer and Jamie, so she brings on Melissa. See the arrows? Well, the train doesn't stop there because guess what ends up getting brought on next? None other than another consultant, that would be Jed Wallace, and his company's name of Street Relations. And that was a long, way around the mulberry bush to bring up the following. And this is what I'm going to remind y'all of in a few hours' time from now. Sarah Nathan is also accused in Blake Lively's lawsuit. Hold on. Of working with none other than Melissa Nathan. And would you be surprised to find out Melissa Nathan and Sarah Nathan are siblings? They are sisters. Melissa and Sarah are sisters. And Sarah Nathan works at Page Six, or, its owner is New York Post, and then Page Six, kind of like the more tabloidian section. But at this point, it's all a tabloid to me. And Sarah Nathan is accused. Now, she's not being sued as a defendant, but Melissa Nathan is accused of using her connections, including her own sister, Sarah Nathan, to run a smear campaign against Blake Lively. Now, did any of this actually happen, girl? The jury is going to have to decide. It's one of the items still up on, the table for a decision. And even if Tag gets dismissed from this and they're able to get off the hook, the retaliation is still on the table because the Tag is only accused of aiding and abetting in the retaliation. Justin Baldoni's Wayfarer and the It Ends With Us movie, those two are still on the hook for retaliation, and that's going to trial, or they're going to have to settle before trial. Like, the judge let that keep going. So I said it at the very end of 2024, might have been the beginning of 2025. But I said, I'm saying this out loud because I just want to make sure I get it on the record, but 2025 is going to be the year, I said. We're going to look around by the end of this year. Everybody and their mama is going to be saying, oh, we know the news is fake. We know PR companies. Put a 1 in the chat if you remember me saying this, if you were around at that time. I said, mark my words, very soon, and it's going to be because of this Blake Lively and Justin Baldoni lawsuit, but it's going to be very, very soon. I said 2025 is going to be the year where all of a sudden it's going to be like common knowledge oh my Lord remembers, it's going to be like common knowledge that PR companies plant fake stories. Now, I didn't have time to find myself saying that, although I do plan to do that unless somebody wants to do the homework assignment of go in and find where I said that. But I think it was at the end of 2024. It must have been the very beginning of 2025. But I said it. I said, this case is going to be the one that just makes it household knowledge. Everybody sitting at the dinner table is just going to know that a lot of the stuff we read is, yeah, fake, but some of it's not even fake. It's true. But the reason that it gets put out is because somebody's PR team put it out. Stories have to be so-called, green lit. They have to get the green light to ever even be published in these money changer tabloids and money changer magazines. Okay. Things have to be approved. And certain things, they're allowed, but it's like, who wants to run that story? Have you ever put it in the chat? You ever tried to get the news to run something? You ever tried to get a mainstream media outlet to run a story about something? They almost never do. They almost never do because they have their own agendas. They have their own, stuff already planned out. They have their own green light. They have their own green lit stuff. And so it's like, there was a time, it wasn't that long ago, where I was being called a conspiracy. We were being called conspiracy theorists by saying things like that now are just public and common knowledge. And I did predict this. So I need to go find the prediction where I made that prediction. However, now we're, fast forward a year and a half. And by the time the trial starts, a year and a half, we're almost on, up to trial. We're on the eve of trial. It's supposed to start next month. It's April right now. The trial is supposed to start in May 2026. And the only claims that survive are not defamation. They're not harassment, not harassment. The only claims that are really surviving is one little contract dispute. And I say little because it's only a very small part of the original, what they tried to go for, what Blake Lively tried to sue for. We have one little contract dispute, and the whole rest of the lawsuit is retaliation in the form of a smear campaign, whether it be against Tag, which may get dismissed, may not, or whether it be against Wayfarer, or whether it be against It Ends With Us. The whole lawsuit now isn't about harassment. It isn't about employment. Remember, Blake Lively said she was bringing this lawsuit because of all the victims. All the victims, she wants to let them know. And y'all know I have a problem with this type of thing when they say this, and it's a PR thing to say. FKA Twigs did it recently. She was saying, I want to bring this lawsuit against my ex-boyfriend Shia LaBeouf because I want to do it for all the women who can't afford a lawyer and who were never able to stand up to their abuser. And it's like, bitch, you could just give them some money to sue. You're really not doing it for the women who can't afford a lawyer. And that's okay. Like, I'm not even mad about that. People should bring lawsuits because they feel that they have been wronged and they're trying to get justice in a court or in a court of law. You shouldn't bring a lawsuit because you're trying to get justice for people who are not named in the lawsuit and have nothing to do with the lawsuit. And I don't believe that is ever what Blake Lively was doing. That is my personal opinion. I could be wrong. But if you ask me my personal opinion, I don't think she was bringing this lawsuit for everybody who can't get a justice, everybody who can't sue, although that's a noble cause. I just don't think that's what she really was doing. I think she was pissed. She was mad about the negative PR. She really thought Justin Baldoni was paying a PR team, a Jed Wallace type, to be behind it. And I think she sued because she was pissed, and that's fine. There's nothing wrong with that. She can sue if she wants to. But this whole thing now about I'm doing it for all the victims of assault and harassment and this and that, well, all those claims done fell away, and the only thing left is retaliation and one contract dispute. But if you will recall, I've always said that was the heart of this case. The heart of this case is these PR companies. That's all that's left. A little contract dispute, and the rest is PR company, smear campaign, digital can't be traced, we can bury anyone, going on Reddit, creating narratives, seeding narratives in a way that is completely untraceable. It's sinister. They're running propaganda ops. Now, the reason that I don't really feel that bad about either like, so-called side of this case is because they were both doing the same thing. Both of them had strong and powerful PR. In fact, and indeed, one of the strong and powerful PRs turned against the one and went and go pack tails with the other. They're doing the same thing. But for me, this case always has, from the very beginning, from my very first words that I ever spoke about this case publicly, it's about the smear campaign. And I was biased too, because I had already heard of Mr. Jed Wallace. I had already been familiarized with him, and it was not as a PR guy. It was as Bam Margera's wellness contract enforcer. The guy that Bam Margera from Jackass had to get on Zoom with every day and take his medications and pills and show Jed Wallace that he took them. Jed Wallace wrote declarations in court in Bam Margera's case against MTV and Paramount for the Jackass 4 movie. Jed Wallace wrote declarations saying that he was a pro, basically, at linking up high-profile celebrities with rehabs and treatment home resources. So now all of a sudden he's like the Reddit extraordinaire, the what would you call it, connoisseur of black market media campaigns, according to Blake Lively. Now, again, that hasn't been proven in court. These are just all allegations, and anything related to Jed Wallace was dismissed on personal jurisdiction grounds. So that's why I was interested in this case in the very beginning. It had nothing to do with harassment claims on set. Now, what I've always said, and I do mean it, I did mean it then, I do mean it now, if there was harassment on that set, that's horrible. And of course I would care. But to me, it was always about this. What is this Jed? Well, I want to get inside. I want to see the cogs, the little parts, the springs, the levers. I want to see how the sausage is made in this PR world. I want to see those texts. I want to see how they influence public perception. I want it to become public and discovery and at trial, which YouTubers they're communicating with. How, if they are at all, are they influencing and pushing and manipulating us? How are they giving people their marching orders, and how are they making it completely untraceable? That's always been my interest in this case, and that's pretty much the only thing surviving. So without further ado, let me pull up. So that was the web. Remember Sarah Nathan, that's the sister of Melissa Nathan, and we're going to get back to her later because we are going to end up talking about, by the end of this video, some other stuff that Sarah Nathan has written. Stuff about Bam Margera, stuff about Justin Bieber. We're going to look at the timing of those things. We're going to look at how it relates to her trustworthiness or her credibility. Now, devil's advocate, a lot of people would say, who is giving Page Six credibility? Okay, sure. It certainly isn't the New York Times, which is also, a periodical that is, or a news source that is mentioned in this lawsuit. But just because it's not the New York Times doesn't mean that it's not a substantial and significant syndicated platform. Lots and lots and lots. I would say millions of people every day come across a Page Six article. And if you add the Page Six and the TMZ and the Daily Mail and the People magazine and the Us Weekly and the Billboard and the it starts to create a pervasive public perception. And that, to me, is something worth looking into, and at Sarah Nathan in particular. But before we do that, I want to get into the main body of the video, which is this order. Came out yesterday from Judge Lyman. This is the opinion and order. As you can see, it is dated as of yesterday, April 2nd. The lawsuit, again, like I said, we're not going to read every single word, but for the first couple, page or two, I will. This lawsuit grows out of events occurring during the production and promotion of the Hollywood film It Ends With Us, and the very public fallout between its two co-stars, Blake Lively and Justin Baldoni. Baldoni and his co-defendants, the Wayfarer parties, now move for judgment in their favor on all claims. Okay, so you follow? Justin and Wayfarer and them, all the defendants, moved for judgment on the pleadings They wanted a summary judgment and a judgment on the pleadings, I think. They basically said, Judge, Your Honor, you've now seen everything that they have to offer on Blake Lively's side. You've seen all their arguments. You've seen all the evidence that's going to come out. And they have not made any claims. So you have to dismiss it. That's basically what Justin Baldoni and the Wayfarer parties asked of the judge. The judge said they bring 2 motions to do this. A motion for judgment on the pleadings. Yep, that was the first one. And a motion for summary judgment. For the following reasons, the judge said, the motions are granted in part and denied in part. In particular, the judge goes on, the motions are granted. So they're all granted except Lively's 4th cause of action, which is retaliation against It Ends With Us movie and Wayfarer. So it was retaliation, which would violate California law. So that's one claim that survives, retaliation. The next claim that survives, that doesn't get dismissed, is her 7th cause of action, and that is against Tag. Tag was sued by Blake Lively for aiding and abetting the retaliation from count 4. And the only other existing claim is the 9th cause of action for breach of an agreement called the Contract Rider Agreement. Okay, and that is also against It Ends With Us. So there's a contract dispute and 2 retaliation claims. One's retaliation straight up, and one is aiding and abetting. The following facts are described in summary at the outset, with a more detailed description of the events when we get into it when it's relevant. The facts are undisputed for purposes of these motions, except where otherwise noted. So he's like, this is all going to be the facts that the parties agree with each other on, unless I say, okay, Blake says this, Justin says this. The facts are undisputed. Okay. The facts are undisputed for purposes of these motions, except where the court says otherwise, and constructed in Lively's favor as the non-moving party. Okay, so y'all, probably would be, why? Why is the judge constructing these arguments in Blake Lively's favor? Have any hands? Show of hands? Does anybody know? Put your hand up, let me know. The judge is construing all facts in a light most favorable to Blake because he has to. He's required to. Blake Lively is the non-moving party. The moving party are the Wayfarer parties. And what are they moving? Moving is a motion, right? They're making a motion, so they're moving for dismissal. They want the whole lawsuit thrown out. But the judge can only do so many things. The judge cannot decide what it is the job of a jury to decide. The defendants and everybody has the right to a jury trial on certain issues. There are certain things judges just don't decide. And so if you can show the judge as a defendant, if you can show the judge that the other party, the plaintiff, did not make any points. So you make a motion. Look, Your Honor, she made no points. She's basically suing for hurt feelings. We did nothing wrong. The judge said, okay, everything I'm about to say is, if there's a dispute about what Blake says and about what Justin says, I don't have the privilege. The judge, I don't have the privilege of using, who is deciding who's going to be the most credible or not. I have to construe things in the light most favorable to Blake Lively because there's certain things that are supposed to go to the jury, and there's rules. So it's not because he's like, oh, Blake Lively is more credible and she's my special favorite. It's the fact that Blake Lively is not the moving party. The moving party on a motion for summary judgment is the one that has the burden. And then so the light most favorable to the person that's not moving, in this case would be the plaintiff, is what the judge has to view the facts of the case through. The lawsuit goes on. This is Judge Lyman's opinion. He says the film at the heart of this lawsuit is based on a successful novel by Colleen Hoover, also called It Ends With Us. Both the book and the film explore issues of DV. The film was co-financed and co-produced by Wayfarer and Sony. Okay, so Sony and Wayfarer both financed and produced the film. They were co-financing and co-producing. The film was It starred Blake Lively and Justin Baldoni. Blake Lively is a well-known actress. Baldoni is an actor, director, and author. Wayfarer is a production studio. It, meaning Wayfarer, aspires. I do sometimes say Wayfarer because it's just kind of hard to say Wayfarer, but I'm talking about Wayfarer if I say Wayfarer. I know Wayfarer is a company, but I'm talking about Wayfarer Studios, Justin's company. Wayfarer aspires to create purpose-driven films intended to inspire connections and promote social change through authentic, impactful storytelling and fresh, creative voices. Baldoni co-founded Wayfarer in or about 2019 or 2020 with Steve Sarowitz. Sarowitz is also the majority investor in Wayfarer. Sarowitz and Baldoni serve as co-chairs of Wayfarer, and defendant Jamie Heath is Wayfarer's CEO. Okay, so see how every sentence here has like a paragraph and a citation number? That is because, remember, just a few sentences above, the judge said, I have to construe all of this stuff in light most favorable to Blake. And the rest of everything else, like where there's no disagreement, like most of this is going to be there's no disagreement. So like everybody agrees here. And he's like, and this is where I got that information from. Okay, so, the SAC, page 56, these are all citations to sources where every single sentence has a citation. These are undisputed facts. Justin Baldoni acquired the film rights to the novel from the author of the novel, Colleen Hoover, about May 2019. Few years later, May 2022, Wayfarer incorporated It Ends With Us movie, LLC, and this is what you're going to see it referred to as here throughout this opinion and order. So when you see this IEWUM, that is It Ends With Us movie. In 2022, they started It Ends With Us movie to develop and produce the film. Later that year, after meeting with Baldoni in New York, Blake Lively agreed to play the lead role in the film. She was going to play the character of Lily Bloom, opposite of Baldoni as co-lead in the role of Ryle Kincaid. Now, I do think that it's perfectly acceptable and fine and legal and allowed and whatever for a film's owner and producer to also be the star in it. However, once I've gotten to the end of, where we are so far with this Blake Lively, Justin Baldoni lawsuit, it does kind of raise the question of whether or not that's really the wisest decision for like liability purposes, because you have the director of the film, the producer of the film, and the owner of the film, or I should say an owner, and a financier of the film, all of these things, who's also in a DV movie kissing and beating on an actress who's also kind of like his independent contract. Like, again, I started this whole thing with the caveat that I do think it's totally fine. I think it's allowed. And in a perfect world, you really should be allowed to do it. But, knowing what we know now, was it necessarily, did it open, let's say, did it open him up to some liability that he wouldn't have been exposed to had he not also played the star in the film? Yes, I think so. And I think he would probably agree. But I would be very interested in hearing his opinion on that. Not that he talks to me or I've ever spoken to him, but, it's something I wonder. Okay, so later that year, 2022, after meeting with Justin Baldoni in New York, Blake Lively agreed to play the lead role in the film, Lily Bloom. And she was going to play that character opposite of Justin Baldoni, who again owned the film, directed the film, produced the film. He was going to be the co-lead in the role of Ryle Kincaid. Blake's agreement to perform that role is documented in an offer letter. Okay, we're going to need to remember offer letter. Okay. Oh, wait, I wanted that to be green. Hold on. See how they put things in quote? These are kind of like the defined terms. It's not just any old offer letter. It's a specific offer letter for the purposes of this document, and it's the agreement to perform as Lily Bloom in the movie. Filming began the next year. That would be 2023. It's so interesting because filming began May 15th, 2023, and the lawsuit, the trial is going to begin May 18th, 2026. So that's just very interesting to me anyway. So filming began May 15th, 2023. It stopped, however, on June 14th, 2023. So like they filmed for a month. Why did they do that? Well, because there were labor strikes by the Writers Guild of America and SAG-AFTRA. Remember the writers' strikes of 2023? During the first phase of production of the movie, all filming took place on a set in New Jersey. Remember that, it will be important. All filmings during the first phase took place in New Jersey. As described further below, Lively contends that various incidents took place during that first phase of filming that amounted to harassment and contributed to a hostile work environment. Okay. And again, y'all, this is Lively, Blake Lively's contention. So that's an undisputed fact. Blake Lively contends, she believes, she tries to say, she argues, various incidents took place during the first phase of filming, that first month. Where did the first phase, are you doing active listening? Where was the first phase of filming for the first month? That's right, New Jersey. Yes. So all that first phase stuff happened in New Jersey, but Blake is like, okay, well, I was as harassed and subjected to a hostile working environment during that. Okay, fine. That's her contention. Several months later, it's now November. In anticipation of the strikes ending and filming resuming, Blake Lively's attorney sent an email to Wayfarer and It Ends With Us movie, listing a set of 17 items, okay? A list of 17 items that Wayfarer and It Ends With Us movie would have to address to remediate their alleged misconduct before Lively would agree to return to production. Remember the list of 17 items? The list was entitled Protections for Return to Production. The list of 17 items included, among other things, provisions related to the presence of intimacy coordinators on set and the execution of nudity riders before rehearsing and filming intimate scenes. So what we're doing right now, again, I want to just, if you're just coming in, hi, hello, drop a like. Thank you. Thank you. We're going to be here for a long time today. So grab your popcorn. We're going to be going through this lawsuit, this opinion in order with the Blake Lively thing. Hopefully by the time we end this video today, y'all are fully aware and fully comfortable knowing pretty much every single thing you need to know about what's going on in this case as we move forward. So I don't even possess probably the physical capacity, although maybe I do, to read every single word on 152 pages today. However, I am going to read every single word in this recap because I want to remind y'all what all the things are that are undisputed. Yeah, he said this, she said this. These are kind of like that happened. And it sets the tone for the rest of what's going to be coming up. Okay, so I'm on page 3 if y'all want to follow along. On January 4th, 2024, Blake Lively, Justin Baldoni, and Jamie Heath and others met at Blake Lively's apartment. I think that was in New York. And it was at her request to discuss her concerns regarding the first phase of production and to approve the conditions for her return. So she wanted to have a little powwow at her house. It was Blake Lively there, Justin Baldoni, Jamie Heath, and some other people. She wanted to discuss her so-called protections when she wants to come back to work. So the protections were later incorporated into a contract rider agreement. I'm going to call this the CRA. Okay, when I say CRA, that's this. And what is this again? This is a rider is something you attach to the back of a contract that otherwise stands on its own. The contract stands on its own, but you can put a rider to the back. And these are other, we're adding that on. It's, it rides on the back of the first contract. So the rider, we're going to call the CRA, and the R stands for rider. And that was the terms that were demanded by Blake Lively, the so-called protections. Those were all in this contract rider agreement. Now, this is going to become important later, but I want to prime you and let you know. Blake Lively, oh no, that was the ALA. Never mind. Okay, we'll get to the ALA. Okay, so that's the contract rider agreement. It is kind of like a contract in and of itself, but technically speaking, it's incorporated into a previous contract they had already entered into. Okay, the contract rider agreement. And that was signed by It Ends With Us movie and also Blake Lively's loan out company, Blake L. Inc. Okay, this was in January 2024. And again, this was so that they could all go back to finishing recording. They never finished filming the movie. They would have been long finished by then, but they got interrupted. The movie started filming in May 2023. It stopped filming the next month in June, and then they were just on hold from filming for like 6 months or 5 months. It was not until November where they started talking again about, okay, we're going to be going back to set soon. So Blake Lively had months and months to kind of figure out how she wanted to handle it. I'm not even saying that she didn't experience whatever she says she did on set, although I'm not feeling like she definitely experienced everything she said she experienced. But she had a lot of time to do things that otherwise in a normal course of business or normal course of filming a movie, she wouldn't have had all that time. Because there would only been like 2 more weeks of production, 2 more weeks of filming. They had filmed for 4 weeks. Her contract only ran for 6 weeks of filming. Well, in order for her to come back, because her 6-week contract expired, she had some leverage. And she was like, well, if you want me to come back, you got to do some stuff, including making me a producer, including letting me have editing power. I mean, all kind of stuff. I've seen some funky writers at my old job. Did you? Honestly, I haven't watched the movie because all the drama. I did. I watched it. Okay. So production on the movie resumed January 2024 and took place primarily in New Jersey. So even here, they primarily filmed in New Jersey. But there were just a few days they filmed in California. Okay, so most of the stuff that she complains of, as the judge stated earlier on in this opinion, is stuff that happened in New Jersey. She was upset or mad or whatever, undissatisfied, unsatisfied, whatever you want to call it, with what happened to her on the set the first time. And that was all New Jersey, all New Jersey. Filming concluded February 9th, 2024. So I just want to stop and take a look at this timeline. They started filming May 2024. They filmed all the way through June, middle of June 2023. May 2023 to June 2023. So they had like 1 month of filming. Then they came back and really only filmed for another month. So it wasn't like they were filming this movie for a year and a half, but it almost took that long to get it filmed. And there was all kind of stuff that happened in the meantime, including strikes. So they were done filming by February 9th, 2024. During the following weeks, the parties worked on editing and promoting the film. Blake Lively indicated that she did not wish to jointly promote the movie with Baldoni. She was concerned that her appearance with him would be viewed as an implicit stamp of trust or an approval of him. She didn't want to seem like she was co-signing him. The film later finally premiered in August 2024 and was released to the public on August 9th, 2024. In the run-up to the premiere and after Blake Lively and her husband Ryan Reynolds had, quote, unfollowed Justin Baldoni on social media. So Ryan Reynolds and Blake Lively had unfollowed Justin Baldoni. Wayfarer and Justin worked with their public relations consultant, Jennifer A. Bell. Remember we saw that web earlier? And that was to engage crisis communications specialists, including Melissa Nathan and Jed Avery Anthony Wallace. I don't know if that's really his last name. Not only that, they engaged these people through their respective firms, which are Melissa Nathan's firm, the agency group, that's TAG, and Jed Wallace's firm, Street Relations. What happened next, the judge says, is hotly disputed and will be described below. This is good writing. I mean, imagine having the task of having to put into just 3 pages the whole entire buildup of this. And I think the judge or his clerk, whoever wrote this, did a great job of that. What happened next is hotly disputed and will be described below. In short, Blake Lively claims that Wayfarer, Justin Baldoni, and their consultants engaged in a campaign to injure her reputation, and this was out of retaliation for her claims of hostile work environment. Okay. So let's run through the procedural history quickly. Initially, the case was filed December 31st, 2024. There was an amended complaint Blake filed February 18th, 2 months later, 2025. And the operative second amended complaint, she filed another amendment in July 2025. September 2025, the Wayfarer parties, that's the defendants in this case, filed a motion for judgment on the pleadings. They supported this motion with a memorandum of law and a declaration of Ellen S. Garofalo. Okay. A few months later, November 12th, 2025, Wayfarer, the defendants, filed another motion to get rid of this lawsuit, but instead of a motion for judgment on the pleadings, this was a motion for summary judgment. The Wayfarer parties also filed a Rule 56.1 statement, the declaration of Alexandra A.E. Shapiro. So if that name sounds familiar, it is. Who can, show of hands? We need a call. We need a tip line. I'm going to do a show of hands to make sure the class is paying attention here. Who is Alexandra A.E. Shapiro? Where have we seen her before? Diddy's trial. That's right. Yes, Diddy's trial. Sean P. Diddy Puff Daddy Combs. She was the one that Mims kind of characterized as the appeals. Like her whole job was to sit there in the trial and make sure they had some type of ground for appeal or look for grounds of appeal. That's what Mims had said. So, Diddler. Yep. Okay. So they filed a Rule 56.1 statement. Docket number 953, the declaration of Alexandra A.E. Shapiro, attaching a large number of exhibits, a memorandum of law, and the declaration of Mitra Ahourian, Justin Baldoni, and Jamie Heath. Okay, so then the next month, December 3rd, 2025, Blake Lively filed her own stuff. This was a memo in opposition. So she opposed their motion for judgment on the pleadings, and she also opposed the Wayfarer party's summary judgment motion. She also filed a counter statement to their Rule 56.1 statement with her lawyer, Michael J. Gottlieb, attaching a large number of exhibits as well as a declaration. Not only that, she supported her stuff with a separate declaration by Don Saladino. That same month, just a few days later, a week or so later, 10 days or so, December 12th, 2025, Wayfarer then filed a reply to her oppositions, and they had some more declarations in support of the motions. Okay, the judge goes over the legal standard for a judgment for motion on the pleadings. We're not going to get into all of this, but we'll read a little bit here. Judgment on the pleadings. So remember, just to recap, Justin Baldoni and the Wayfarer parties filed two separate motions. Either one of these motions could actually technically get this whole lawsuit dismissed. One is called, and the one that was filed first was called a motion for judgment on the pleadings. The one that was filed second, which could separately, independently get rid of all these claims theoretically, is called a motion for summary judgment. For our purposes here today, both of them are just motions to get rid of this lawsuit, okay, for our purposes here today. But there's two of them. The first one is called a motion for judgment on the pleadings. So judgment on the pleadings under Rule 12C of the Federal Rules of Civil Procedure is appropriate when the movant, that would be Wayfarer, Justin Baldoni, them, establishes that no material issues or issue of fact remains to be resolved. Again, judgment on the pleadings, a judge can make a judgment on the pleadings if the people trying to get the lawsuit dismissed establish there's actually no material issue of fact that remains in dispute. There's not actually a dispute. Judgment on the merits of a case can be made merely by considering the contents of the pleadings. The same standard applies to motions to dismiss as motions for judgment on the pleadings. Thus, a court must accept all factual allegations that Blake Lively made as true. So even if the judge takes every word Blake Lively said as true, at least for the purpose of allowing it to get to the next stage, which is the jury, even if the judge accepts everything Blake ever said as true, even if the judge accepts everything Blake Lively said as true, is there actually an issue? Is there actually anything up for dispute or debate left? The court does not have to accept all allegations that are contradicted by other matters. It has to be granted unless the complaint includes enough factual matter accepted as true to state a claim that is plausible on its face. A pleading that offers mere labels or conclusions does not cut it. Summary judgment, okay, that was a motion for judgment on the pleadings. Now, this is summary judgment is appropriate where the movant, that would be Justin Baldoni, shows there's no genuine dispute as to any material fact. Okay, so these are the things. It seems kind of hard, like, oh God, how do you get it dismissed before it even goes to a jury? Well, Blake Lively and any movant in these cases has a burden to prove certain things, even at this stage. And this is the Iqbal Twombly standard. A genuine issue of material fact exists if the evidence is such that a reasonable jury could return a verdict for Blake. So if if a reasonable jury could answer in favor for Blake, then has to be allowed to go to a jury. But if no reasonable jury could ever possibly ever give Blake Lively a win, then it's no need to put it to a jury, because no jury is ever going to grant her that. And before it ever gets there, there have to be certain legal requirements that Blake has to meet. The movant bears the burden of demonstrating the absence. So in this case, the movant would be Justin Baldoni and Wayfarer, Jamie Heath, and them. They had the burden when they were trying to move for summary judgment or motion to dismiss that they're moving for. They have the burden to demonstrate that there is no dispute of material fact. And they did on 10 out of 13 grounds. So that was very successful for them. In deciding a motion for summary judgment, the court has to construe the evidence in the light most favorable to Blake and draw all reasonable inferences in Blake Lively's favor. That is a rule. He doesn't have a choice. He has to do that. Okay, so I think y'all get that. So then there's the discussion aspect, and I'm going to read a little bit of this, and then I think after this section, we'll start doing a little more skimming until we get to some specifics. Okay, so here's the discussion section. Blake Lively brings 13 claims against the Wayfarer parties. Okay, we're going to read through them. Number 1, S harassment in violation of Title VII. I'm not going to read the exact parties she brings these all against because it's going to take forever, but these are not all, these claims don't go against all parties. Y'all can pause it and read who they go against. But number 1, S harassment. Number 2, retaliation in violation of Title VII. Number 3, S harassment in violation of the California Fair Employment and Housing Act. This is the FEHA or FEHA. I'm going to call it FEHA. FEHA. The California Fair Employment and Housing Act, okay? So retaliation in violation of a federal employment act, which is Title VII. And she also brought retaliation in violation of the California, that's the FEHA. I'm realizing I said in my other video this was a federal law because I saw the F. And I was like, oh, that must be FEHA. That must mean federal. No, it's not. So if y'all watch that one, just so you know, this is not a federal. This is a state. I just misunderstood and misspoke I guess not misspoke. I just was confused. We'll say that. Okay, so number 1 is S harassment under Title VII. Number 2 is retaliation under Title VII. Number 3 is retaliation under, S harassment under FEHA. Number 4 is retaliation under FEHA. So we have 2 retaliation and 2 S harassment claims One under state law. Two under state law, two under federal. So you understand, you see this matrix in your mind? One as harassment federal, one as harassment state, one retaliation federal, one retaliation state. Number 6, failure to investigate, prevent, or remedy harassment in violation of FEHA. Number 7, aiding and abetting harassment and retaliation in violation of FEHA. And that's where she brings in the PR groups: Nathan, Tag, Abel, Wallace, Street Relations. Number 8, breach of an agreement of the ALA, the Actors Loan Out Agreement. Number 9, breach of the CRA. Remember, that's the one where she had to renegotiate and all that, the rider. Number 10, false light, invasion of privacy in violation of Article 1, Section 1 of the Constitution of California. Number 11, as harassment in violation of California Civil Code 51 against individuals Justin Baldoni and Jamie Heath. This is one of the ones that fell away. Number 12, defamation and defamation per se against Wayfarer, Baldoni, and Heath. And this was by way of Brian Friedman. And number 13, civil conspiracy against all defendants. Through their 2 pending motions, the Wayfarer parties move for judgment on all claims. Their motions for judgment on the pleadings and summary judgment overlap in many respects. To the extent they don't overlap, the parties dispute whether the court should, in considering the motion for judgment on the pleadings, also consider factual disputes presented in the motion for summary judgment. The judge does a, discussion on whether it should or should not. He gets into the Blake Lively contract signing stuff. I'm going to skip through a large part of this just because it's kind of tedious. It's very evidence, specific, fact-based, and it's got dismissed anyway. So I don't really want to spend that much time here because I'm going to get tired before we get to the parts y'all really want to hear. Okay, so the CRA, okay, so this was just all the background between the actor loan out agreement, how those agreements work, precedent, the CRA, that contract rider agreement, how those work. So the judge says, this is on page 20, the ALA, the actor loan out agreement, is unenforceable. Okay, so Blake had sued for violations under this ALA, but it's unenforceable. It was never validly formed. It is unenforceable against the Wayfarer parties because the agreement contains conditions precedent. Okay, what is a condition precedent? Well, that is a fancy way of saying Blake did not sign the agreement. So you might have heard, people saying, or you might have read in the news, Blake didn't sign this contract, so she can't enforce it. That is where this, page 20 is where it starts, is where that comes from. The ALA was never validly formed because there were conditions precedent that Blake did not meet for obligations to attach to the Wayfarer parties. She did not sign the inducement. She responds that Blake Lively responds by saying, it doesn't matter that I didn't sign it. Want to know why? Because everybody was acting as if I signed it anyway. So they can't, it can't be, they use it sometimes, they hold themselves to it sometimes and not now. That was her argument. She said that they waived any condition of her signing it through their conduct. Before turning to the merits of Blake's arguments, the court addresses 2 preliminary issues. First relates to choice of law, and this is where he gets into whether California law or New York law prevails. He does a long little analysis, and then he says, but given the fact that Blake, failed to respond, and viewing the papers and the circumstances as a whole, the court deems that Blake's contract claims against Wayfarer were abandoned. She says that they acted under the contract even though she didn't sign it. The judge says, no. Now, it ends with us. Movie LLC raises 2 variants of the same type of argument, why the ALA is unenforceable as against them. They contend that even if it was a binding contract, They specifically provided that their obligations did not arise until Blake signed the agreement. And because that condition never occurred, they had no obligations. Their obligations never kicked in, and they cannot be held liable under the agreement. And the judge agreed with them. The judge did agree with them. So now let's scroll right on through. Waiver of the conditions precedent. Even if it was already formed, obligations didn't arise until she signed it. Right. Yeah. Okay. So we're still doing the scrolling. Okay. Notice and cure. Okay. So that was one of the reasons why the judge dismissed Blake's contract claim as it pertains to the ALA. But the judge says there's a whole nother reason besides the fact she didn't sign it. Like, let's say she did sign it. It's still not enforceable. And you still can't sue for breach of contract under it because Blake had certain obligations under this contract, even if she had signed it, which she did not. But even if she had signed it, she had certain obligations under the contract she didn't even do. So it makes her lawsuit like she can't sue them. There was a so-called notice and cure requirement that Blake Lively had to meet. When she saw that the contract was being violated, she had the duty under the contract, which again, she did not sign. So it got dismissed already on that grounds. But like, let's say she did sign it. Let's say they found, oh, look, here's a missing signature page. She signed it. Okay, fine. You still can't sue them. It still can't go to the jury. Why? Because in that contract, under the contract, if Blake, that she's trying to hold them to, right? She's trying to hold them to it. So she got to be held to it too. And under that contract, even if she had signed it, she had a duty to give Justin Baldoni, Jamie Heath, It Ends With Us movie, to give them notice and an opportunity to fix the problem before she sued them. And she didn't do that. She didn't give the required time. She didn't give them notice. No actionable breach of agreement because Lively did not satisfy the ALA's notice and cure provision. The court agrees with It Ends With Us movie. Okay. Lively's argument lacks merit because she failed to comply with the notice and cure provision in this context. It's not an affirmative defense. Under the terms of the ALA that Blake is trying to sue under, you breached the contract. You breached the ALA that we signed. ALA stands again for Actor Loan Out Agreement or Actors Loan Out Agreement. It was a contract that Blake's loan out company and It Ends With Us movie entered into, and Blake had obligations under it. She didn't meet the obligations. Under the terms of the ALA, notice and cure goes to an element of a claim for breach of contract, which the plaintiff, that's Blake, and not the defendant, has to satisfy. The elements for breach of contract are three. There's three elements. Number one, a contract exists. Number two, plaintiff's performance or excuse for non-performance. Okay, so the plaintiff, before you sue somebody, you have to have performed your part of the contract. And then number three, the defendant, Justin Baldoni, Wayfarer, It Ends With Us movie, had to breach. Okay, so number one, a contract exists. Number two, there was a breach or a really good reason for a breach. And number three, number two is the plaintiff has to do it. The plaintiff has to do the thing that they say they're going to do. Number three is the breach. Then there's four, damages, which of course, has to be damages. Blake's breach, or any plaintiff in a breach of contract action, bears the burden on each element. So as you can see, I have number two highlighted here because this is where Blake's fails. Okay, to make a contract, she's suing for breach of contract, right? So to make this claim out, she got to prove four things. Number one, did a contract even exist? Well, first of all, kind of no, right? Because she didn't really sign it. You got to sign the contract. But let's say it did. Number two, did Blake do her part under the contract too? First of all, did she perform her part under the contract? Everything she said she was going to do, did she do it? Number three, did the defendants, in this case will be Wayfarer or It Ends With Us movie, did they breach their part of the contract? And number four was their damages. So the plaintiff bears the burden on all of these. As a general matter, a notice and cure provision can implicate both the second and third prongs. So a notice and cure provision can implicate whether the plaintiff performed under the contract and whether the defendant breached it. With respect to the third prong, where the contract expressly provides no act or omission shall constitute a breach, okay, the California Court of Appeals. This is kind of some of the nitpicky, like, really down in the weeds. I don't really want to get too down in the weeds here. I'm reaching the conclusion, okay? This is precedent. Okay, so the ALA, so the same conclusion as the precedent applies here. The ALA expressly defines company's breach as arising only where Lively first, okay. So the company can only breach. They actually defined breach. So the judge doesn't have to go digging around for a definition. The ALA that Blake Lively sued under, the one that she sued saying you violated the ALA, she's saying they breached it. Okay, well, there's actually a definition for breach in that exact contract that the parties agreed to. So a breach can only occur if Blake first notifies It Ends With Us movie of whatever the breach was supposed to be. And she had to have provided 30 days from the receipt of the notice for them to fix it. They had to have an opportunity to fix it. The judge says this unambiguous language means there can be no finding of a breach. A necessary element of Lively's case, she first has to establish compliance with the notice and cure provision because it is Lively who bears the burden of demonstrating the breach. It Ends With Us movie did not need to specifically identify the notice and cure provision as an affirmative defense in its answer. It therefore did not waive the reliance on provision on failing to do so. Plaintiff need not always plead and prove. Okay, whatever. The court therefore now turns to whether Lively satisfied the notice and cure provision of the ALA, and the court said she did not. She did not. In her summary judgment papers, she points to no notice that she sent and addressed to It Ends With Us movie, which specifically raised the specter of breach. The November 9th, 2023 email sharing the protections for return to production made no mention of breach of any agreement, which makes sense given that the ALA had not been executed. So Blake didn't even sign this agreement that she's now trying to hold against Justin Baldoni and them. The offer letter, though, that she did sign contained, oh no, you didn't sign. The offer letter doesn't need a signature, contained no terms regarding as harassment or retaliation. And her December 20th, 2024 cease and desist was not addressed to It Ends With Us movie, and therefore plainly she failed to comply with the contract, the ALA's specified notice and cure procedures. That contract that she's now trying to sue up under required writing addressed to It Ends With Us movie under the attention of Jamie Heath, setting forth specific alleged breach. This is what she agreed to in this contract she's trying to enforce. She did amend her CRD complaint to name It Ends With Us movie, but simply amending her complaint does not comply strictly with the ALA notice and cure procedures. Lively also initiated this suit the very next day. So she deprived It Ends With Us movie LLC its 30-day opportunity to cure under the ALA. Now, Blake Lively tries to defend this by saying any issues regarding a cure window are now moot because her second and first amended complaints were filed more than 30 days after the suit, but the judge said, no, that ain't going to cut it. The judge says, in sum, Lively has failed to raise a triable issue regarding It Ends With Us breach under the relevant contract language because she did not comply with the ALA's notice and cure provision. Summary judgment in the favor of dismissing the lawsuit against everybody is warranted on this claim for an additional reason. Okay. So that was the ALA. All right. That one falls away. It's one of the 10 claims that got thrown away as against Blake Lively. But there's another half of the contract claims. That was half of the contract claims. She sued for breach of 2 contracts. First one was the ALA. That got kicked out. First of all, she didn't sign it. Second of all, she didn't even do what she was supposed to do under it, even if she did sign it. So goodbye. But there's another contract. That's called the CRA. That's the one with the rider. The rider. Her attempts to enforce the CRA and its provisions specifying there shall be no retaliation of any kind against Blake for raising concerns about the conduct described in the letter stand on firmer ground. It Ends With Us movie makes two primary arguments. Okay, so this is a different contract. I just want to make sure it's very clear because I do all this work, it's like a lot of effort, a lot of labor. So I want to make sure I'll actually understand it. The ALA was the original agreement. But remember, they shut down production, and then that means, her original 6 weeks, whatever, expired, and she needed to come back on, all that, and then they had to renegotiate. That was the CRA. So this is a separate contract. Even though it's called a rider, it was like way later that they entered into it. It Ends With Us movie is trying to get this one dismissed as well. And they offer two primary arguments why Blake Lively cannot enforce the CRA. They basically argue the same stuff, similar stuff. Like that's not enforceable. She can't sue for breach of contract. It argues that the CRA was not binding because it made reference to the ALA. Remember, that one is not enforceable. And therefore, since it referenced the ALA, then this one's not enforceable too. The second argument that It Ends With Us movie is making in an attempt to try to get the whole thing dismissed on the breach of contract claim. So the first one, again, because Blake Lively references the ALA and the ALA is moot, because Blake Lively and the CRA, this contract she's suing under, it references the ALA. And that ALA is moot. So the CRA got to be moot too. The second argument, It Ends With Us movie, they're like, all right, if that's not going to work, what about this argument? Hear this one out. The CRA had no consideration because everybody knows that contracts require a few things: offer, acceptance, consideration. And in order to have acceptance, you have to have a meeting of the minds. There's no consideration. The judge said neither one of these arguments has merit. The court starts with the second argument regarding consideration. One of the bedrock elements of contract formation, in addition to the manifestation of mutual assent, right? That's meeting of the minds, is the exchange of bargained for consideration. Consideration is often defined as some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. It is well established that the slightest consideration is sufficient to support the most onerous obligation. There must still be something of real value in consideration. So Justin Baldoni, It Ends With Us movie, really specifically, he's arguing, or the company is arguing, there was no consideration. Blake didn't have to give nothing up. We were basically forced to just sign this thing so she could come back to the movie. And we were entitled to her coming back to the movie anyway. The judge said, regardless of where the burdens in the case fall, there is still sufficient evidence in the record to conclude that the CRA was supported by valid consideration. In particular, when the parties entered into the CRA, Blake Lively's legal duty to return to the set for a second half of production was at least doubtful or subject to honest dispute. The offer letter, the only agreement by which she was actually bound to perform, required her to provide exclusive principal photography services for up to 6 consecutive weeks. 6 consecutive weeks. Consecutive is the operative word here. During the run of production. Filming paused 1 month into production due to the Writers Guild and the SAG strikes, but by its terms, the offer letter did not force or oblige is the word they use here, Blake to commit to more than 6 consecutive weeks of filming. Her duty to continue with filming at that point was therefore subject to at least some uncertainty. Y'all follow? Put a 3 in the chat if you understand what the judge is saying here. That it's not, okay, yeah, Blake had no duty to show up. The judge is saying, but it was like at least genuinely in dispute whether, 6 consecutive weeks means 6 consecutive weeks. She filmed for, 3, 4 consecutive weeks, maybe close to 5, and then there's the set shut down. Well, the next consecutive week, they couldn't make their movie. So, okay, too bad, so sad. So the judge is saying, I'm not going to go all the way out and say she didn't have any duty to come through on the contract. But the judge is saying, what I will say is it's up for dispute. And remember, what is the, why is this word escaping me? Oh my God. The standard. What is the standard here? The standard is there a reasonable dispute or is there a dispute of material fact? Okay. There is a dispute. Did she actually have to come back or not? Because if she didn't have to come back by law, by contract, if she didn't have to come back because her 6 weeks ran out, then the consideration is that she decided to come back. You're going to get, I mean, nobody would dispute, like they needed somebody to play Lily Bloom. Nobody would dispute that they would have lost a lot of money if they would have had to start over filming because she's the star, one of the two stars. So the judge is not saying, oh, that's obviously consideration. The judge is saying that could be construed as consideration, and that is not ripe for me to decide right now on summary judgment. Because why? Because it leaves open a genuine dispute of material fact. There really is a dispute. Did Blake Lively have to come back and finish? Probably not, because it wasn't in the consecutive 6 weeks. Her agreement to resolve that uncertainty by returning to set constituted valid so-called, quote, consideration. Okay, so what was the consideration according to the judge? Her agreement to coming back and filming after the 6 weeks. And it's months and months and months and months and months and months after the 6 weeks. That is what the CRA, in fact, recites. It states that the parties wish to confirm the conditions upon which Blake agreed, or Blake L., her company, agreed to cause Lively to render acting services on the film following the break in production. The clear implication is that absent agreement conditions, Blake L would not cause Blake Lively to return to set. And because it was unclear whether Blake L had an obligation to cause Blake Lively to return, the CRA was supported by valid consideration because Blake Lively did in fact return to filming, according to the judge. Now, for the second argument, so that was the consideration argument, but Wayfarer, it ends with us movie. They said, hold on, we got another argument for you real quick. Okay, that one don't work, fine. Because they made 3 arguments to get rid of the last contract, right? And it worked. All 3 of the judge agreed with all 3. So here, they make 2 arguments to try and get rid of this CRA claim, the CRA, the rider. They also argue that the CRA is not enforceable. Why? Because it makes reference to the ALA. And as we already talked about ad nauseum at this point, the ALA was not executed. That argument, the court says, has no greater merit. The CRA states that it shall be deemed incorporated into the ALA, but the CRA also states that in the event of a conflict between the CRA and the ALA, the CRA will govern. So the CRA trumps it anyway, and they all signed that one. The interpretation of an unambiguous contract is a matter for the court. So the CRA claims go on. They also argue that she can't prove damages, but you don't have to prove damages at this point. And even if they could, it's not up for the judge to decide. It ends with us motion for summary judgment with respect to Lively's contract claim under the CRA is denied. So this is one of the 3 claims that's going to survive. All right. This is one of the 3 claims that survives. The It Ends With Us movie is still on the hook for the contract claim under the CRA. So this is not one of the 10 out of 13. This is one of the 3 out of 13 that survives. Now the court gets into a little discussion about Blake Lively's employment status. And when I say employment, I'm talking about capital E has a definition under the law employment. Blake Lively's first and second causes of action allege harassment and retaliation in violation of Title VII. Okay, Title VII of the Civil Rights Act. Her first and second. That's her first and second causes of action. She also has a 5th cause of action alleging retaliation under California Labor Code Section 1102.5. The Wayfarer parties raised the threshold issue of whether the laws cover Blake Lively in the first place. Is Blake Lively the type of individual who The legislature actually contemplated even being able to benefit from the Civil Rights Act or from Title VII. Whether an individual worker should properly be classified as an employee or an independent contractor has considerable significance for workers, businesses, and the public generally. It is a prerequisite for suing under the California Labor Code or, Title VII that there was, in fact, an employee-employer relationship at the time that any supposedly retaliatory action occurred. So Blake Lively's harassment and retaliation claims under those provisions can only proceed if she was an employee. She cannot have been an independent contractor. And under the law, these are different. The court will assess Lively's employment status under Title VII and California Labor Code 1102.5 in turn. So first the federal statute, and then he's going to get into the state one. Title VII covers employees, but the statute's definition of the term is circular. The act states only that an employee is an individual employed by an employer. In determining whether a person is an employee for the purposes of Title VII, courts have applied the analysis derived from the Supreme Court's decision in Community for Creative Nonviolence versus Reed. Okay, employee. The relevant factors are drawn from the general common law of agency rather than from any particular state's law, given the fact that federal statutes are intended to have uniform nationwide application. Okay, so is she an employee? Is she not? There's a bunch of factors. And the judge says there's no dispute that Blake Lively had extensive involvement in and control over many of the decisions related to the film and her role. So she had a lot of agency. That's the word they're looking for. That's the thing they're trying to analyze. She does not dispute the underlying facts related to her letter in the Producers Guild of America. Okay, so interestingly, the judge is kind of holding her Producers Guild of America move against her. Not explicitly, but in a roundabout way, because the judge is, in a sense, using Blake Lively's own words against her. Remember that letter that she sent over or had Justin Baldoni or Wayfair, whoever, send over to the Writers Guild, the Producers Guild, or whatever, and whoever it was, and it was like all these things she did on the movie to show, that she deserves a producer credit. Well, the judge is like, what's good for the producer credit goose is good for the dismissing your lawsuit gander. He said she had extensive involvement in the movie. She doesn't even dispute it. She has this letter to the Producers Guild of America, the PGA letter, led the location. So these are, as reflected in the letter, Lively states that she did the following: led the location shift from Boston to New Jersey, helped solve all cost and logistics, personally called and wrote emails, reviewed and reshaped the creative production for all key locations, reviewed and shaped costume design, all characters, went through hundreds of casting tapes, zoomed with every cast member, responsible for the firing of the first assistant director, helped to block, or maybe associate director, helped to block the staging of every scene, reviewed the COVID protocols, managed the politics of HR concerns, was the director's partner. So, this is just like over a page of stuff that she did on this movie. Hand selected 90% of the songs on the film, solicited and implemented feedback based on test screenings, worked closely with international teams on everything from posters, commercials, book covers, and beyond. So this is way more than what any dinky old employee would be doing. Worked with cast, representatives, producers, showrunners, tour managers, spouses, travel agents, and beyond to coordinate their schedules for press, going as far as successfully begging their bosses to release them for press for our film. The judge says there is no dispute that in addition to a flat sum guaranteed as payment for her work on the film, Lively was entitled to contingent compensation based on the film's performance, as well as compensation in the form of credit or bonuses for awards. The offer letter committed Lively to providing 6 weeks of exclusive principal photography services plus startup prep services, subject to her approval and availability, and up to 3 post days. At any later point, she was free to accept other work and to perform on other films. So that's another factor that they look at in determining, was somebody an independent contractor or was somebody an employee? Did they have the opportunity to do other stuff? Was it a limited time, or were they full time for the rest of forever until they quit? Stuff like that. Even the PGA letter itself indicates that Blake was shooting another film while simultaneously working a minimum of 10 hours a day on post-production for It Ends With Us. As for her working hours during principal photography, the offer letter cabined them as follows. So just more stuff. She's doing all this stuff. So the judge then gets into the analysis and said the undisputed facts. So even taking everything Blake Lively is saying as true, this would still reveal that Blake Lively enjoyed a degree of economic independence sufficient to make her an independent contractor. Not every factor weighs equally in favor of that, but when you look at all the factors together and put them on a scale, she was an independent contractor. And if she's not an employee, if she's an independent contractor, that means she's not an employee. And if she's not an employee, capital E employee under the law, she cannot bring a claim under Title VII. And the Title VII claim was sexual harassment, hostile working environment, and retaliation under Title VII. But she didn't just sue under Title VII. She sued under Title VII. She sued under California law FEHA. And she sued under labor code, 1102 or something. Maybe that's the same thing. But she didn't just sue under Title VII. She sued under state and she sued under federal. But under federal, you can't bring this claim if you're not an employee. And she's not. She's more like a producer, independent contractor. The court analyzed each Reed factor separately and recognized that they did overlap. There were certain undisputed facts that were relevant to one factor that also were relevant to others. And I'm not going to get into all these, like reading them line by line, but some of the Reed factors that the judge considered were the right to control. The right to control favors independent contractor status. Let's see if I can see. Skill, Blake Lively's skill level. That tips heavily in finding independent contractor. The source of the instrumentalities and tools, the hired party's role in hiring and paying assistants. So that's one of the factors the judge had to consider under that precedental case, Reed. The duration of the relationship and whether the hiring party had the right to assign additional projects to the hired party. That was another such factor that the court considered and weighed in favor of contractor. So all of these are so far that we've looked at go in favor of she's an independent contractor. She's not an employee. If she's not an employee, that means she cannot bring a claim under Title VII. So the S harassment falls away. Goodbye. Ta-ta. As far as under Title VII of the Civil Rights Act. The method of payment was a factor that the judge considered. Again, that one is also in favor of independent contractor and does not go to speak to being an employee. The next factor, whether the work was part of the regular business of the hiring party. And finally, there is no dispute the Wayfarer parties were in the business of producing films, and Lively's work related to the business objective. But that doesn't even necessarily mean that means she's an employee. And then they balanced all the Reed factors, balancing them all together. The judge decided that all of these things tip the scale. If one side of the scale is the employee, yes, she's an employee. And the other side of the scale is no, she's not an employee, she's an independent contractor. Putting it on the scale is tipped. Independent contractor wins. I guess this one. Independent contractor is what she is. Not an employee. Now, because Blake Lively was an independent contractor, the Wayfarer parties are entitled to summary judgment on the Title VII claims. And this kind of hopefully will help you understand like how this works, right? Like this means there's no triable issue of material fact. The standard for summary judgment is there's no triable issue. There's no triable issue where somebody was not an employee. I mean, that's like you just can't bring a claim. Title VII Civil Rights Act is made for employees for Title VII. She's not an employee. Tough titty. Don't know what to tell you. Can't bring it. Jury could feel as bad for her as they want to. That law does not apply to her. She is not of the class of people that the law could apply to. And the judge gave all the different reasons we just discussed as to why. Now, that claim falls away. It's one of the 10 that fall away. But what about California law? Because remember, there's 4 causes of action under this one, at least, that I can think of. That's 2 retaliation, 1 retaliation, and then 1 aiding and abetting retaliation. That's the PR people. And then 1 as harassment and 1 aiding and abetting the harassment. So now we're going to get into that. California law. The Wayfarer parties also argue that Blake Lively was an independent contractor and not an employee under California's business to business exception. So a lot of times states will adopt their own versions of these federal laws, and it'll be the state law, and they'll tweak it a little bit, add some more protections. And that's what happened in California. It goes farther than the federal law. The Wayfarer parties argue that Blake was an independent contractor, not only under Title VII, but they're also saying she still counts as an independent contractor under the state law she's trying to sue under. Under California law, as under federal law, whether an individual is an employee or an independent contractor is a question of law. So that means a judge can decide it. It doesn't have to go to a jury. Juries decide questions of fact, if the facts are up for dispute, and judges decide questions of law, whether someone is an employee or not, for example. Similar factors to those that compel the conclusion that Lively was an independent contractor for purposes of the federal law, the Civil Rights Act, Title VII. The similar factors also require rejecting her claim under California law as well. Okay, so the judge is saying we're going to do a similar analysis here. All right, so some of the things they take into consideration. A, the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. B, the worker performs work that is outside the usual course of the hiring entity's business. And C, the worker is customarily engaged in an independently established trade, occupation, or business. So these are just the factors that California will have considered in the test. In order to avail itself of the test of bona fide business to business relationship, the contracting business has to satisfy one of the following each of the following 12 conditions. I'm not going to go through all of those. If a business is unable to establish any one of the criteria, the inquiry ends. If those 12 conditions are satisfied, the determination of whether a person is an employee or an independent contractor is governed by the test set forth by the California Supreme Court. And so he does this long test, but then he says the same undisputed facts that establish Blake Lively was not an employee under the federal laws, Title VII specifically, also establish that she was not an employee under the state law, basically. Okay. So then the judge gets into this. Hold on. Summary judgment is therefore granted on Lively's Section 1102 claim, which means it falls away. So the S harassment under California law falls away. It's gone. But there's the little, we call it a wrinkle over here, of extraterritoriality. Extraterritoriality. That means outside of the territory. Okay, Wayfarer parties present one last hurdle to Lively's California statutory claims, and they assert that these laws apply only to conduct with a so-called sufficient nexus to California. And that is lacking here. In other words, Blake is trying to sue in California under California law for stuff that happened in New Jersey. She responds that California statutes apply because the parties included a California choice of law provision in the ALA that she didn't sign, I will remind you, and that she didn't perform her obligations under, I will remind you, but she's still trying to rely on it. Oh, the contract I didn't sign has a California choice of law provision. She also says that even if it didn't have that provision, because she knows that's probably not going to get her very far, she didn't even sign that document. Her claims, she says, still possess a so-called sufficient nexus to California. Like they're decently related. And this is important because when a state passes a law, the law is supposed to apply inside the state. It's supposed to protect people inside the state. Yes, citizens of the state, residents of the state, but also anybody who comes to visit the state. The state has an interest in having laws that protect people that come there, protect people that do business there, protect people that drive through there on a road trip. So California law is not supposed to apply to stuff that happened in New Jersey, unless I'm sure you could think of some instances where it might. Somebody is aiming their actions at California. Maybe you have all your business set up to only aim your products to people in California or something like that. Sometimes California law might kick in, but in general, California law applies to people in California, whether they live there or not. It's usually going to apply to people there. Like if you're speeding in California, you get a California ticket in California. If you're speeding in New Jersey, what the hell does California's law have to do with you? So the judge is saying, well, Blake Lively is saying there is enough of, sufficient nexus of activity, sufficient minimal contacts, you might have heard it called before. The court, though, concludes California statutes, this is important, get your notebook out. California statutes do not apply to Blake Lively's S harassment claims. Okay, so the S harassment claims cannot be covered by California law. And they also cannot be covered by federal law. Why? Because she's not an employee. She would have had to be an employee. So those go away. But now we're talking about California law, has nothing to do with an employee. This has to do with the fact that stuff didn't even happen in California. The S harassment claims did not happen in California because they happened on set in New Jersey. And so for those claims, by Blake's own admission, they did not happen in California. So the California law cannot help her. But the judge says they might. California law might, not does for sure, not probably, might protect her retaliation claim. So let's get into that analysis. He says there's a presumption against extraterritoriality. Okay. As the California presumes that its statutes do not apply outside of California. It's written here, do not have extraterritorial application. But what that means is California just presumes their laws are not meant to apply in New Jersey. That's a presumption. As the California Supreme Court has repeatedly explained, no matter how far the legislature's power may theoretically extend, courts presume the legislature did not intend for a statute to be operative with respect to occurrences outside of the state. Okay, so we can all assume that when they wrote these laws, they weren't thinking, let's apply them to every other state. No, they were like, this is California law. We're going to make it a law in California. Applying this presumption, courts have found that FEHA, okay, so the FEHA is the California State Labor Code, Section 1102. Okay, so this is the California State S harassment and California State retaliation lawsuits being brought under the state law. Because remember, she brought some under federal. Those all got thrown out. But now we're talking about the California law. First, okay, wait. Applying this presumption, courts have found, so there's also precedent in the past, where courts have found that the California, we'll call it FEHA, that's the California law, does not apply to claims that arise outside of conduct that happens in the state. It does not appear that the Ninth Circuit or the Supreme Court has addressed whether it may apply extraterritorially. The highest California court to address the issue was the California Court of Appeal, and they determined that FEHA was not intended to apply to non-residents where the tortious conduct took place outside of California's territorial boundaries. The California Court of Appeal based this conclusion on its review of the statute, the legislative history, etc. It does not appear that any court has addressed the extraterritorial reach of California's civil code. Okay, so no court has addressed exactly this question. This is an issue of first consideration. The judge is saying, I'm going to call an audible. Y'all can appeal this if you want to. I'm not really basing this on specifically any prior stare decisis or any precedent, because no court seems to have addressed how far California's FEHA could reach. But he says, I do know the law was adopted to plug a hole in FEHA, Civil Code Section 51.9, by prohibiting S harassment not only in the employee context, but also in contexts involving other types of professional relationships. As with FEHA and so FEHA in California, see, this is confusing to me. Sorry, I'm saying it. I said it right the first time. I corrected it, but it was wrong the second time. FEHA and the California Labor Code Section 1102.5 are two different California statutes. Okay. That's kind of in the weeds. It really doesn't matter, like, for the purpose of what we're doing here, but I do want to make sure I'm being precise, especially, where I realize I've said something wrong earlier in the video. But there are two California statutes. One is FEHA and one is the California Labor Code Section 1102.5. The statute on its face has no indication that it was even meant to apply to stuff that went on in New Jersey. The court doesn't need to make a definitive holding, though, with respect to the territorial reach of the law, because Blake Lively has not contested the assertion that the presumption against extraterritoriality applies. Therefore, the court is going to assume that it doesn't apply outside of California. This dispute poses a very interesting and important question regarding parties' ability to contract around extraterritorial limitations in state statutes. But the judge says, however, I don't have to address that important question. Want to know why? Because the ALA was never executed. Ooh, that came back to bite her in the behind again. Because if she had executed that ALA, she had signed it, then he would have to do this whole brand new decision. And that is whether parties can contract around, sign their rights away, basically, to have this contract spread across the nation, across the world. The judge said, a good thing for me, I ain't got to address that because Blake neglected and failed to ever even sign the ALA. Okay, so Blake Lively asserts that her California S harassment and retaliation causes of action are sufficiently related to California, such that they do not implicate extraterritoriality concerns. She's like, oh, all this stuff was all happening in New Jersey, but it still relates to California. And basically, the judge says that's not going to cut it. She brings S harassment claims against the following parties. It Ends With Us movie, Wayfarer, Justin Baldoni, Jamie Heath, and she brings all those claims under FEHA. That is the California FEHA. And she also brings claims against Justin Baldoni and Jamie Heath under the separate specific code of personally against them. The crux of these claims is that the defendants harassed Lively and subjected her to a hostile work environment on the basis of her sex or gender. Lively's allegations center largely around conduct that occurred on the set of the film during the first phase of production in New Jersey. This on-set conduct occurred outside California and cannot support applying the statutes extraterritorially. Blake tries to get over that hurdle by saying key decisions that enabled the behavior happening in California. The judge just really does not buy it. Lively contends that the harassment also continued after filming. She says the Wayfarer parties planned, coordinated, and implemented a smear campaign from California, and that was intended to cast her in a false light. Brian Friedman gets brought up. None of these actually provide enough of a substantial connection to California as is required by FEHA. No reasonable jury could conclude that Jamie Heath's text message about being at home with his family bore a sufficient relation to the S harassment that Lively claims to have later occurred on the set. Okay. Lively's efforts to invoke retaliatory acts taken in California as a basis for sustaining her S harassment claims are without merit, the judge said. Finally, failing to hire additional HR personnel to share HR policies with cast and crew was not the core of the alleged wrongful conduct, so she fails there too. That case is plainly inapplicable here, as there is neither allegation or evidence that Heath or Baldoni concocted a plan from California to harass Blake Lively. So that's pretty strong right there. The judge said there's not even an allegation, and there's definitely no evidence that Jamie Heath or Justin Baldoni concocted a plan from California to harass Blake Lively anywhere, much less outside the state. The court therefore grants judgment on counts 3 and 13 of the Second Amendment complaint because those claims lack a sufficient nexus to California. Basically, TLDR, judge is saying you cannot sue her under California law for all this stuff that happened outside of California. That's just not how it's going to be able to work. Now, that's all for that's all for the S harassment claims. However, Blake Lively's retaliation claim against It Ends With Us movie, Wayfarer, under California Labor Code 1102.5, and against It Ends With Us movie, Wayfarer, Melissa Nathan, the agency group, and Jennifer Abel under FEHA do not suffer from similar deficiencies. These claims, so they don't suffer the same way that as harassment do. Why? These claims involve the allegation that These claims involve Blake Lively's allegation that the defendants subjected her to an adverse employment action by launching a coordinated campaign to cast her in a false light during the publicity and promotion of the film, also to discredit her in the event that she publicly disclosed her concerns about harassment and other unlawful conduct, and they irreparably damaged her career and future earning capabilities in direct retaliation for her participation in a protected activity. Now, this is one of the most important sentences of the entire lawsuit. Coming up. Because there's a lot of discussion in the news, online, YouTubers, TikTokers, bloggers, everybody and their mama. There's a lot of discussion about, well, Blake wasn't as harassed. She has no evidence that she was as harassed. Blake Lively's as harassment claims have been dismissed. So why on earth is this how can you retaliate for something that didn't happen? How can you retaliate? Oh, she reported as harassment. Well, the as harassment didn't exist. That's a question that people are asking. And this sentence in the lawsuit right here explains exactly what it is. What's the answer? The judge says, whether these acts occurred, like whether it actually happened, and whether they actually are retaliation, whether they amount to retaliation, is not the point. It's not for debate right now. They're not issues that the court has to consider in connection with the issue of extraterritoriality. The only issue now, because remember, what are we doing? We're not deciding the case. The judge is not deciding, did the XYZ element OP happen or not? The judge is not deciding on credibility. The judge is deciding, can the case make its way in front of a jury? And the judge said, yeah, it can. Why? Because I don't have to address the issue of, did retaliation occur? Did a coordinated smear campaign occur at all? Was it to cast her in a false light? We don't know. Was it to discredit her? We don't know any of this. The judge said, but the fact we don't know isn't the point. I don't even have to know. Why? The only issue now, right now, at this point, at this venture, at this juncture, is whether the core of the alleged wrongdoing possessed a sufficient nexus to California. The judge said in relation to the retaliation, which was Blake is alleging was the smear campaign, if we view everything Blake Lively said in the light most favorable to her, and if the judge takes everything Blake Lively said for face value, which he has done on the S harassment claims, but she didn't make her case. He did the same analysis on the retaliation claims, and he reached a different result. He said, if I take everything Blake Lively said in her complaints as true, there is, or there would be, if it's all true, there would be a sufficient so-called nexus to California. Lively alleges that in August 2024, Wayfarer retained California residents Tag and Nathan. Okay, first thing, right? He's going to start telling you all the factors that made him keep this claim in. And I think this starts to get into like some of the real meat of the complaint, because this is the stuff that survives. We already did talk about one thing that survived. Do you remember what it was? It was the CRA contract dispute that is surviving. Nothing else we've talked about in 90 pages survives. 93 pages, the rest of them all got dismissed so far. But we're now on the second one here, and this is the retaliation. The judge is now getting into the reasons why he decided the way he did. First of all, Lively alleges that in August 2024, Wayfarer retained California residents Tag and its owner, Melissa Nathan, to, quote, get ahead of Lively's grievances by planting false narratives portraying her as a bully and a mean girl. Now, importantly, the judge did not find, yes, they did do this. The judge said, I don't have to find whether they did it or not, because right now I have to take what Blake says at face value. Baldoni and Heath, California residents, then directed the execution of this alleged retaliatory smear campaign over the weeks and months that followed on behalf of themselves and It Ends With Us movie and Wayfarer. All of those are also California residents. So the judge is like, It Ends With Us movie, California resident. Wayfarer, California resident, as far as like, business is concerned. The agency group PR Tag, California resident. Melissa Nathan, California resident. Justin Baldoni, California resident. Jamie Heath, California resident. So now we're starting to see there might be a sufficient nexus to California. Blake Lively further alleges that the Wayfarer parties launched a second wave of retaliation executed through their California-based attorney, Brian Friedman. So also, according to allegations, Brian Friedman helped with some of this so-called campaign, but he's also in California. The acts forming the basis of Blake Lively's retaliation claims largely occurred Let me start over. The acts forming the basis of Blake Lively's retaliation claims largely occurred in and were directed from California. The rule against extraterritoriality does not pose an obstacle in those claims because all these people were living in and operating from California. The rule of extraterritoriality did come into play on the S harassment because the events giving rise to those claims supposedly happened in New Jersey. But the smear campaign is what Blake is calling the retaliation. And the smear campaign happened by all these California people. Now, there was also Jed Wallace, who's Texas-based, but he wasn't even mentioned here. The Wayfarer parties offer no real fight here. They focus almost exclusively on the S harassment claims. And they state only with respect to the retaliation claims that Melissa Nathan and Jennifer A. Bell cannot be liable for retaliation wherever it occurred. The court will address that argument at a later point. But for now, the court says Lively's 4th, 5th, and 7th causes of action survive. And this is really the heart and soul of what's still left standing. So the judge says Lively brings retaliation claims against It Ends With Us movie and Wayfarer under the federal law, Title VII, under FEHA, which is a California plug the hole law, and under California Labor Code Section 1102.5. So 2 California laws or statutes and 1 federal. She also brings aiding and abetting retaliation claims under FEHA against Melissa Nathan's company, Tag, and Jennifer A. Bell. Okay, so she's suing It Ends With Us movie. She's suing the production companies under 2 state statutes and a federal. She's suing the PR companies, the kind of third parties, Nathan, Tag, and Jennifer A. Bell, under just only 1 statute, which is FEHA. That's the California state one. The court has granted judgment on the Title VII and Section 102.5 claims on the grounds that Lively was an independent contractor. Remember that? Title VII, she can't get any relief under Title VII because she's not an employee. She had a lot of control over that movie. She was an independent contractor. Same applies for the state law. Both FEHA and Section 1102.5. She was an independent contractor. That is why the court granted judgment on Title VII. However, this is probably another of the very few most important sentences in the whole entire case we're going to read today. And this really answered the outstanding question I had. A person, and a person is going to end up having specific legal definition. A person does not need to be an employee to bring a retaliation claim under FEHA. Once again, to bring a retaliation claim under the California law, fair, equal house, fair employment house, whatever, to bring a claim successfully under it, you do not have to be an employee. The retaliation is actually prohibited against any person who engages in a protected activity. So Blake doesn't have the same issue with trying to prove her retaliation or trying to put her retaliation claim into the next level to make it in front of a jury that she did with S harassment. Because under FEHA, anybody can be retaliated against, not just employees. And this makes sense because remember when I told you a lot of times the states will put in a law that will give a little more protection, a little more of a boost. As previously explained, the Wayfarer parties don't even move for judgment on Lively's FEHA claims on the basis of her employment status. So they don't even try to make that argument because they know anybody, whether they're an employee or not, can make a FEHA claim. The court thus turns to Blake Lively's retaliation claims under FEHA. In doing so, the court finds that there does exist genuine issues of material fact requiring trial. As to the claims against It Ends With Us movie, Wayfarer, and Tag is in a little bit of a limbo. However, Melissa Nathan and Jennifer A. Bell are entitled to have their claim dismissed. They are entitled to summary judgment. They get to be off the hook. With respect to the aiding and abetting claims pleaded against them, the court withholds judgment on the agency group. He'll get to that. He's going to circle back around. Before proceeding further, the court notes that the discussion below treats It Ends With Us movie and Wayfarer as Lively's employer. But the court is like, that doesn't mean I've determined that they were her employer. I already told y'all she's an independent contractor. So I'm about to say employer, employee, employer in this one section, but that's not me saying she's an employee. That's just me keeping the language consistent with the statutes I'm relying on and with the cases I'm relying on. But he's saying it straight up. The discussion below is going to treat It Ends With Us movie LLC and Wayfarer LLC as Lively's quote employer. She's not their employee and they're not her employer. But I just got to conform the language of the statute and case law. They use the term employer even in cases involving independent contractors. Okay. We're going to treat them as joint employers. Okay. Legal background. FEHA provides in broad terms that it is unlawful for any employer or person to discharge, expel, or otherwise discriminate against any person, okay, not employee, any person, just for simply because the person has opposed any practices forbidden under this part, or because the person has filed a complaint or testified or assisted in any proceeding. This subject mentions the term discrimination or discriminate, but it has long been understood that discrimination means retaliation as well. The statute defines person as including one or more individuals, partnerships, associations, corporations, limited liability companies, legal representatives, trustees in bankruptcy, and receivers or other fiduciaries. Okay, so that could be any individual. So that, I mean, Blake Lively is a person, okay, under the law. And so is Blake L. And an employer is any person regularly employing 5 or more persons or any person acting as an agent of the employer, directly or indirectly. FEHA's anti-retaliation provision is intended to aid enforcement of the FEHA and promote communication and informal dispute resolution in the workplace. As with retaliation claims brought under Title VII, which is the federal law, FEHA retaliation claims contain 3 elements. So what does Blake have to prove? What does a plaintiff have to establish? Number 1, she engaged in so-called protected activity. Number 2, she was subjected to an adverse employment action. And number 3, there was a causal link between the protected activity she supposedly engaged in and the defendant, the Wayfarer party's actions. The first part of the plaintiff's prima facie test establishing a protected activity requires demonstrating that Blake took steps to oppose practices forbidden by FEHA. Now, this is very important. Of course, a plaintiff's conduct may constitute protected activity not only when the plaintiff opposes a conduct that is ultimately determined to be unlawful discriminatory conduct, but also when the plaintiff, that's Blake, opposes conduct that she reasonably and in good faith believes to be discriminatory. It does not matter under FEHA whether the challenged conduct is ultimately found to violate FEHA. So if you take this proposition and apply it to the Blake Lively Justin Baldoni case, Blake Lively is saying her protected activity was reporting a hostile, so-called, according to her, a hostile working environment. When she reported the hostile working environment, she made everybody around aware. Justin Baldoni, it ends with us, Jamie Heath, that she was reporting a hostile working environment, at least as far as what she understood it. Now, of course, we already know Justin and Wayfarer and Jamie and all of them, they're like, it was not a hostile working environment. First of all, she wasn't even an employee. That could all be true. But that is not really the question that the FEHA is asking. The question that the FEHA is asking is, when Blake Lively reported this supposedly hostile work environment, and then the smear campaign that she believes a smear campaign, because she could have hallucinated the smear campaign, but was it a reasonable, good faith belief that she was actually being discriminated against? Not will a judge later decide that it was discrimination or retaliation, but did she have a reasonable ground to believe she was being discriminated against? The plaintiff does not need to prove the underlying complaint had merit. So she could be saying, okay, I'm complaining of hostile work environment, and it could not be hostile at all. Put another way, the judge said, a plaintiff can bring a retaliation claim where she has opposed conduct that she reasonably believed to be discriminatory, even if a court later determines the conduct was not actually prohibited. In a case where a court has not found an underlying FEHA violation, the question is the reasonableness of Blake Lively's belief that she was opposing a practice that was actually prohibited by FEHA. The reasonableness inquiry contains both a subjective and objective component. The plaintiff has to show that she actually really did believe it. And what does she have to believe? That her employer was engaged in an unlawful employment practice. And she also has to show that her belief was objectively reasonable in light of the facts and the record presented before the judge. The objective reasonableness of an employee, and again, it could be independent contractor's belief that the person she's complaining about Has engaged in a prohibited employment practice must be measured against existing substantive law. Okay, the second part of the plaintiff's test, the adverse employment action, requires that terms, conditions, or privileges of employment had to be materially altered. Treatment that is reasonably likely to impair her job performance or prospects. So, would this supposed smear campaign? So, let's say Blake Lively is able to actually prove that there was a smear campaign. It was set up in retaliation for her complaining about harassment or hostile working environment. Let's say she was even able to prove that. If she was even able, sorry, I got distracted by y'all's comments. I always do. Shout out to people leaving comments in the live chat. On the other hand, treatment is reasonably likely to impair her. So, if she suffered any type of career prospect, career damage to career prospect, let's say she's able to prove that a smear campaign happened, would that interfere with her future career prospects? Maybe. The judge is saying we got to let a jury decide on that. Actions that threaten to derail an employee's career are objectively adverse. So it's not just an adverse employment action under your current boss. Is it going to have an adverse action on your employment anywhere? If you go and try to get a job somewhere else in your industry or in your field and you can't because of something that happened at your last job, that is still under this FEHA law, the adverse employment action as required. In the Title VII context, which California courts have drawn guidance from, the Second Circuit has observed that at some level of generality, any action taken by an employer for the purpose of defending against the employee's charge could be characterized as adverse to the employee. But it's not any action that qualify as adverse. It's up for debate. It's one of those facts that's up for dispute. Very fact specific, these cases. Reasonable defensive measures do not violate the anti-retaliation provision of Title VII. So we're back to talking about the federal statute, but the reason we are is because California courts have used those cases about the federal Title VII statute as guidance. We've already established Title VII doesn't apply to Blake Lively because she's not an employee. But under California law, the factors don't have to apply. Excuse me, she doesn't have to be an employee. We already talked about it. The FEHA, it could be any person. So, all right, let's look how the federal courts have decided Title VII, they're saying. Well, it makes sense that, okay, yes, abusive, hostile workplaces should be held accountable. We all agree. They shouldn't be able to discriminate based on impermissible things like race or gender, sex, or, religion or national origin. Okay, we all agree. That's the law. Title VII, the Civil Rights Act. And the courts in California have used the federal court's interpretations of the Civil Rights Act to interpret the FEHA Act, even though the FEHA is a little bit more protective than just the regular, Title VII. But even under Title VII, employers are not required to sit there with their hands tied. If people are making big allegations against you, you can defend yourself. If they're making allegations against you in the press, you can tell your own version of the story in the press. And that can't be considered retaliation. You have to have some level of ability to defend yourself as an employer, especially before it makes it to trial. Defendants have latitude in deciding how to handle and respond to discrimination claims, right? So Blake made a claim and the defendants had latitude to decide how to handle their response. It's not like any and everything they do is retaliation. Notwithstanding the fact that different strategies and approaches in different cases and classes of cases will result in differences in treatment, California courts have likewise held with respect to FEHA that the significance of particular types of adverse actions must be evaluated by taking into account the legitimate interests of both the employer, in this case, that would be Wayfair and the defendants, and the employee or the independent contractor. With respect to the final element, causation, FEHA eschews Title VII's but-for cause standard with retaliation claims. Okay, where there is a triable issue of fact regarding whether the retaliation played a substantial motivating role in the adverse employment action, the FEHA claim is not properly resolved on summary judgment. Okay, so what stage of the trial are we on right now? The summary judgment phase. We have not gone to the trial phase yet. That's not till next month. So, because the judge is saying, because there is a dispute of material fact, was there retaliation? Was there a smear campaign? Was there a smear campaign in retaliation for reporting harassment? All these things are things that the judge says, I can't decide these things. It's got to go to a jury. This claim is not properly resolved here at summary judgment. The complex issue of retaliation involves a factual inquiry into the employer's motivation and intent. These determinations are left to the fact finder. Remember, juries determine facts, judges determine and interpret law, not determine, they interpret law. Here, the court finds there are triable issues of fact with respect to all three elements of Blake Lively's FEHA retaliation claim. Now, importantly, you will note the judge does not say they retaliated. He does not say there was a smear campaign in response and in retaliation. He says there are issues of fact that are up for debate, and that is supposed to be for the jury. The parties appear to agree that Blake Lively did engage in at least some protected activity. She did seem to have a reasonable jury could conclude that Blake Lively opposed practices that she subjectively believed constituted as harassment. A reasonable jury could conclude. He's not saying, oh, I conclude. He said it has to go to the jury because a reasonable jury, I don't know what they're going to say. We're going to have to see if y'all don't settle. But a reasonable jury could conclude that Blake Lively opposed practices that she really in her heart and soul believed, even if she was wrong, were sexual harassment. And she went and she made a claim against it. Maybe she really did think that was sexual harassment. The judge said, I don't know if she did or didn't. It's not up for me to decide. It got to go to the jury. The wayfarer parties have not specifically contested her subjective belief. They have not said she didn't believe that. There is sufficient evidence suggesting she felt she'd been, retaliated against. Then the judge gives some examples. I'm not going to read every single one of them. During the first week of filming, she complained privately to a friend. It's like HR is nuts today. Both of them, I wasn't expecting that. I mean, it's been present, but today I came home and cried. They're just being creeps. So these are things the judge is saying. Maybe a jury could see these text messages to her friend and say, no, yeah, she really thought she was being harassed. Maybe they'll read these texts and say she's a liar. We don't know. We have to let it go to them. Viewed in the light most favorable to Blake Lively, again, the judge's hands are tied. The judge can only perceive and view these facts in a light most favorable to Blake. So doing that and putting on that lens, he said there is sufficient evidence that it was reasonable for her to believe that the Wayfair parties harassed her. By creating a hostile work environment and analyzing this issue, the court does not need to and does not determine whether the relevant conduct was actually as harassment. He said, I'm not deciding whether it was or wasn't. It's about, does Blake Lively reasonably believe that it was? And she might. I don't know. We got to let the jury decide. The relevant conduct has to be discriminatory. A hostile work environment is not one that is bad for all living things in a manner that happens to involve characteristics of the protected class. Rather, it is one that is discriminatorily hostile to one employee or an employee based on his or her membership in the protected class. In other words, a hostile working environment has to have occurred because of the plaintiff's protected characteristic. And she's saying that it was because she was a woman. She identified a series of acts that she claims created a hostile work environment based on her gender, beginning with her work on the film and continuing through the conclusion of the first phase of filming. Several of those incidents would not support a hostile working environment claim. or would only do so in very minimal context. So the judge kind of being a little bit shady. He's like, look, even if this was within the jurisdiction protected by FEHA, even if it did happen in California, a lot of this stuff is not hostile work environment. It's just not. She's just whining. Some incidents come closer to stating a claim. The court begins with the former before turning to the latter. When viewed together, the incidents are sufficient to support a reasonable basis for Lively's complaints, and therefore her assertion of retaliation. But he's kind of like hedging it very severely. When Lively first met Blake, when Blake first met Justin, this was in December 2022. To discuss the possibility of participating in the film, Justin told Blake Lively, who was pregnant at the time with her first boy, that he was circumcised. Oh boy. Baldoni told Blake Lively that he was that. I ain't going to say it again. Lively found the disclosure uncomfortable and unnecessary, but it occurred in the context of a discussion about the different medical decisions people make these days, including circumcision for male babies, a topic that Lively herself may have introduced. More importantly, it occurred before she began working on the film. This could not have created a hostile work environment because they weren't working. Any incidents giving rise to the hostile work environment claim had to have occurred during plaintiff's employment. So this comment, maybe it was as harassment, maybe it wasn't, but it definitely wasn't a hostile work environment, and that's what she's suing under. Other conduct, particularly viewed in isolation, would also not give rise to a claim for hostile work environment. Prior to the principal filming, Justin Baldoni proposed certain edits to the screenplay, including ones related to S relations. Now, Blake Lively said that was S harassment, hostile work environment because the S scenes were gratuitous. Baldoni suggested the scenes involving sexual acts in the context of developing a motion picture involving such adult themes. The judge said this did not create an sexually objectionable environment. Look at the topic of the movie, the judge is saying. It did not create a hostile working environment to women or men because of, on the basis of gender, we'll say. I'm going to say gender instead of this S word because it just gets flagged. Gender is not a protected class. It is this S word, but I am going to just say it for the purposes of this so y'all know what I'm talking about. It would neither be surprising or unreasonable from a creative standpoint for both Baldoni and Lively to have drafted sexually explicit material because this is a movie that has those themes, even if some of it was not to the taste of the other. Giannetti had written to Baldoni that Sony was going to try and get as much tasteful, hot, you-know-what in the movie as they could. As the court previously observed in a case called Max Sweeney, so this is precedent. In context, actors in a play containing sexist dialogue would reasonably understand that dialogue to be part of a performance, i.e., part of the constellation of surrounding circumstances. Like, you have to look at it in the context. This is a previous decision of the court. Expectations, relationships surrounding the play. You can't just look at it without looking at that as a hostility or animus toward their gender. An individual actor in that play might find the experience of performance subjectively painful, but without more, she will not have a claim for hostile work environment because even if the use of sexist dialogue does involve sex, it is not discriminatorily hostile to one employee on the basis of her sex. A similar principle applies here with respect to the creation of the screenplay. Blake Lively complains of fat shaming, but that could not reasonably support a claim. Oh, so the fat shaming claims, the judge is basically saying, no, that's not hostile work environment. Shortly before the work on the film, not that fat shaming can't be a hostile work environment, but the fact specific way that Blake Lively has given the her side of events, the judge says that's not hostile work environment, girl. Shortly before work on the film began, Lively gave birth to a child. She expressed to Justin Baldoni she wanted to be in her best shape for filming. On or around April 23rd, 2023, before principal photography began, Justin Baldoni asked a personal trainer he had consulted with and who was working separately with Lively if the trainer knew what Lively would weigh when filming began. Baldoni's question then found its way back to Blake Lively, who felt disturbed and unsettled that Justin was soliciting information about her weight. On another occasion, Justin Baldoni introduced Blake Lively to a specialist in probiotics, who Lively subsequently discovered also specializes in weight loss. Evidence that an employer made weight-related comments to persons of only one gender could, in a certain circumstance, help demonstrate a hostile work environment. But the record here does not indicate whether any similar conduct was directed toward men, regardless of the conduct. It cannot be reasonably viewed as expressing hostility to Lively because she's a woman or to women in general. This is where the judge starts to be like, okay, let's have a news flash. The physical appearance of a protagonist is part of the product that the producers are intending to offer the audience. Lively herself, the judge says, recognized that achieving a certain aesthetic was part of the job that they both excitedly signed up for. She asked Baldoni if they could do the body scenes at the end of the schedule so she could have sufficient time to work out. She wrote to her agent privately that she was working out twice a day, 4 hours a day in order to lose weight and set the movie up for success. She said sexiness in this film and the marketing, I'm sure, is critical to its success. She also told Justin Baldoni, my husband and I both look at certain roles as athletic events, and this is one of them, and that's great. The judge says, given these statements, Justin Baldoni's actions, even if they could be viewed as gently pushing Blake Lively to lose weight, is not supported by that's not supported by the evidence, could not fairly be described as discrimination because of Lively's gender. Blake also points to certain conduct that occurred during filming, like early in the production phase, Blake Lively and Justin Baldoni filmed a scene in which their characters danced together. The script stated that their characters would be slow dancing completely in their own world, but did not otherwise include details about how the scene would be shot or how the characters would be interacting. The script did not specifically call for any kissing or simulated intimacy, yet Blake claims that during filming, Baldoni leaned in and gestured as if he was trying to kiss her, and that he kissed her forehead, rubbed his face and mouth against her neck, put his thumb to her mouth and flicked her lower lip, caressed her, and leaned into her neck, saying it smells good. The record includes videos of the scene. The scene was shot in front of a large group of people. Baldoni can be heard giving blocking instructions. Both actors are shown improvising. Other actors are there in the background. The judge says there's no question that this conduct might support a hostile work environment claim if it occurred on the factory floor of the executive suite. But in all sexual harassment cases, the court has to carefully consider the social context in which particular behavior occurs and is experienced by its target. The question is whether in this context, Justin's conduct could reasonably be understood to reflect a view about Lively as a woman rather than the specific role that she was asked to play. And the judge says under this framing, it would be very difficult to view Baldoni's conduct as hostile or biased based on gender. He was acting in the scene. Assuming he was improvising, the conduct was not so far beyond what might reasonably be expected to take place between two characters in a slow dancing scene, such that an inference of hostile treatment on the basis of sex would arise. At least in isolation, the conduct was directed to Lively's character rather than to Lively herself. Creative artists, no less than comedy room writers, must have some amount of space to experiment within the bounds of an agreed script without fear of being held liable for sexual harassment. Although these incidents could not on their own sustain a hostile working environment claim, as harassment claims have to be viewed based on the totality of the circumstances. And there is other conduct by Wayfarer in them that presents a closer question. For example, the judge says a reasonable jury could conclude that Justin Baldoni commented on Blake Lively and Slate's personal appearances in ways that made them uncomfortable. Comments of these types can help contribute to a hostile working environment. During the first phase of shooting, the judge says, Baldoni asked Blake Lively to remove her jacket. And when she did, she revealed a partially unzipped onesie. And at the time, she had a lace bra underneath. And Baldoni said, pretty hot, in a tone that made Blake Lively feel on display and uncomfortable. But Blake responded, that's not what I was going for. And Baldoni responded, sexy? And she said, neither. The comment was understood contemporaneously to be inappropriate. Slate told Baldoni that the comments about actors' bodies and their wardrobes ranged from irrelevant to or unnecessary to inappropriate. We're just not doing this anymore. Baldoni rolled his eyes and said, sorry, I missed the sexual harassment training, and walked away. Also that day, Lively was wearing a jacket over a dress with a low-cut neckline. She was not in wardrobe for the movie. When she bent down, and that's kind of interesting to me, like they would even make that distinction, because she used her own wardrobe for the movie. So how is somebody supposed to know she's not in wardrobe? No, it wasn't all. Everything was that we saw was her wardrobe. She did buy some. But like, wait, she wasn't in wardrobe. Who cares? When she bent down to pick something up, her jacket fell open, revealing her dress and cleavage. Baldoni just said, I like your outfit. That's not sexual harassment. I'm so sorry. I like your outfit. While making a back and forth gesture across his chest area. Yeah, I like your outfit. I like your outfit. That's nice. That's a nice compliment. Now, the other thing about the sexy, that's maybe something different. Lively had referred to her own wardrobe as sexy. The judge said Blake Lively referred to her own wardrobe as sexy already, but that didn't open the door to all manner of comments on her appearance. Baldoni also told Slate, who played his character's sister, she was not involved in any sexual content in the film. She was wearing a black leather pants at the time. He said, I can say this because my wife is here. You look sexy in what you're wearing. Yeah, you shouldn't say that. He shouldn't have said you look sexy. That's where I'm going to say, no, you shouldn't have said that. Now, does that give rise to a hostile working environment? That's a question for the jury. That is a question of fact. Then there's the intrusion into Lively's physical privacy. On the second day of filming, Jamie Heath, arrived at Blake Lively's trailer while she was almost entirely undressed and having her body makeup removed. She agreed to meet with him because she had concerns that she wanted to share with him, but she made him promise to turn away from her and face the wall. He agreed to do so. At some point during this discussion, Blake realized that Heath had turned away from the wall to face her and was staring at her exposed body through a mirror. Blake confronted Heath in the moment and he admitted to looking at her like saying, oh, sorry, I like to make eye contact with the people I'm talking to. Now, the Second Circuit has recognized that so-called stares at a woman's body can provide evidence of a hostile working environment. And here, Blake Lively was in a state of undress and specifically asked Heath not to look at her. In another incident, Baldoni and Heath pushed for Blake Lively to perform a birth scene naked, even though her character was in a hospital. They had not previously discussed blocking the scene in this way. She had not anticipated or agreed to be so exposed in the scene. And the offer letter provided that there would be no nudity or simulated sex without the artist's prior written consent and execution of a nudity rider. So again, the judge is saying all this as if it is a fact, but that is because he has to take the facts in a light most favorable to Blake. So it could end up being the case that this goes to trial and then a jury says that didn't happen. Jamie Heath did not. We do not believe Jamie Heath was looking into that mirror. We do not believe that Jamie Heath walked into that trailer while she was getting her body makeup removed. But as of the time being, the judge does have to take he absolutely has to. Leonce said, is the judge a man? Yeah, but the fact that he is basing his analysis with Blake Lively's claims being more believed is required, even if he was a woman. She said, I can see how the judge is interpreting the law, but I also understand how she felt as harassed. I think most women have felt this kind of invisible harassment. Maybe not. And whether or not she felt harassed is the question. This is what the jury is going to be deciding, and that is why the judge is saying it is not his place to decide this. Blake Lively and Justin Baldoni and Wayfarer and all of them have the right, the constitutional right, to have a jury decide whether Blake felt sexually harassed or not. I mean, imagine how shitty of a world it would be if all cases were just up to what judges thought our feelings were. Oh, the judge thought someone felt harassed, so she wins. No, it has to go to a jury. That's just part of it. Yeah, no, imagine all the small things adding up over and over again every day for 12 to 18 hours. I can't. I don't want to be an actor. I don't want to be an actor. I don't want people in my hair. I don't want people doing makeup, body makeup. I don't want to have to breastfeed in a trailer. I don't want to do that. But when you sign up to be the star of a huge $350 million blockbuster or whatever, you gotta kind of, that's your job. So all of that to say, these claims and what you're saying could end up very well being what the jury decides. They might say, yeah, all of this added up over 12 to 18 hours a day for 6 to 8 months, which again, they only really filmed for about a month and a half. So I don't know if you were in here for the whole live. I know I've already been live 2.5 hours. So no shade if you missed it, but I already did discuss that she did not film for 6 to 8 months. She filmed for about 3 to 4 weeks and then for another maybe 3 weeks. So it wasn't even 2 months of filming total over the course of a year and a half. That doesn't to me necessarily mean that there was no hostile working environment. There totally could have been. That's going to end up being for the jury to decide. But yeah, dare to share, she was only on set for 14 days. So at the extreme maximum, she was there 18 hours a day on set for 2 weeks. So, it could still end up being like what you're saying. The jury could hear all of this stuff and be like, wow, I agree. I know what it feels like or whatever. And she might still win. These claims didn't fall away. These ones are still up for the jury to decide, but not S harassment under Title VII because she's not an employee. Yeah, Living Story World said this lawsuit is in two parallel realms of perception. She may believe what happened to her happened, and she may believe it's retaliation. But she's the weapon that went against something because she didn't like what she wanted. She was a part of Post, yes, but she kicked Justin Baldoni out of the editing booth at some point. So she didn't have to even be in there with him. And ultimately, I think Sony sided with her and aired her version of the movie. So she did have a lot of preferential and favorable treatment by the other, produce sponsor or whatever, financier of the producer, distributor of the movie. Lively felt forced to compromise. See, the judge is viewing this in light most favorable to Blake. He's saying it. She felt forced to compromise by performing simulated nudity. A jury could end up saying that wasn't true. She didn't feel forced. They could end up saying, yeah, she felt forced. For the entirety of filming the scene, which took several hours, the set was not closed and everybody could come in and out. Lively has submitted some evidence that industry standards would call for an intimacy coordinator to be present because there was implied nudity and a high hip exposure that constitutes profile nudity, but no such person was present. At another point, for example, of, Blake saying she was discriminated or had a hostile work environment, during work on the screenplay and discussing a sex scene in the film, Baldoni offered that he and his wife beep at the same time, and he asked if Lively and her husband do the same. Ew. Ew. But also during that writing process, after Lively commented that she believed some scenes had become somewhat pornographic, Baldoni volunteered, in the course of claiming that the scenes were not pornographic, that he had been previously addicted to such content. Lively stated that she had never even seen any of such content. And Baldoni later announced that to individuals on set, that Blake had never even seen ography. That may be fair grounds for an author or a director to discuss personal experiences, including those related to sex, as part of the creative process. And the mere mention of sexual content or topics in the workplace does not necessarily support a hostile work environment claim. However, the judge says, Baldoni's on-set comment to crew members regarding whether Lively watched pornography this is where the judge kind of comes out against Baldoni. This had no connection to the creative process, and it singled Blake out in front of others in a way that could be interpreted as related to sex or based on gender. Discussions about a woman's sexual affairs in the past has been able to be contributed to a hostile working environment. Now, again, the judge is saying it could be construed this way, could be interpreted. The judge is not saying it was a hostile working environment. He's not saying it was not a hostile working environment. He's not saying, and no reasonable jury would think this is harassment. He's saying the opposite. He's saying a reasonable jury could hear this and say that this was hostile. They could say that this is not acceptable. For him to say, ha ha, everybody listen, Blake never watched pornography before. Judge said, I don't know if it is or isn't. It's not my job to decide. I got to leave that to the jury. They might think that's harassment or a hostile work environment, though. So the claim has to survive. There are other instances of alleged inappropriate behavior, including one in which Heath showed Lively a video of his wife giving birth. But it suffices for present purposes to conclude, drawing all inferences in Lively's favor, a person in her position could have understood the workplace to at times reflect a gendered and sexualized view of women and disregard for their privacy sufficient to make it a reasonable for her, in her mind, to complain about a hostile work environment based on gender. That conclusion finds additional support in the fact that Lively alluded to many of these incidents in the protections letter. And Wayfair parties wrote that although their perspective differed in many aspects, they found most of her requests reasonable and essential for the benefit of all parties involved. The court does not need to consider whether the acts as alleged would support a jury verdict that they created a hostile work environment. We don't have to decide what the jury's going to decide. I don't have to know. He said it's sufficient. It was reasonable for Blake Lively to believe that it might be. He then quotes Miller, a previous lawsuit, noting that even if a plaintiff's beliefs regarding as harassment are legally mistaken, even if it wasn't as harassment legally, retaliation can still be sustained where the nature of the complaint reasonably falls in the statute's general purview. Now, the judge gets into the final aspect of this analysis on this issue. A jury could also find that Wayfarer and the Wayfarer parties understood that Blake Lively thought they had behaved in a discriminatory manner. Okay, this is very important because I agree. Whether or not they actually harassed, sexually harassed or whatever, whether or not they actually created the hostile work environment, did they know or have reason to believe, did they know, meaning the Wayfarer parties, or have reason to know Blake Lively thought they discriminated against her? Absolutely. She pitched a fit. She had that whole meeting. She said there have to be protections in place. She sent a lawyer and she said, this is not up for negotiation. You have to agree to all 17 of these or I ain't coming back. So yeah, they had reason to know that she at least was saying they discriminated. They knew that she said that. She said it to them. Baldoni stated with respect to the protections letter, of course, we all know this document insinuates that I am unsafe, sexually harassing, etc., etc., etc. After the all hands meeting he shared with friends, they essentially said that Jamie and I are not who we claim to be, and that for us to have a podcast is unsafe because it makes people feel like we are safe. The word creepy and abuse were used in reference to me and my behavior. When Slate, another actress, called Baldoni out on set for remarking on Lively's appearance, he said, sorry, I missed the sexual harassment training. And Jamie Heath, feared that Lively would file an sexual harassment claim against him. The Wayfarer parties, therefore, knew that at least some of Blake Lively's complaints went to instances of alleged gender discrimination and were not just merely unfair treatment. There is enough evidence to bring the issue before a jury. Again, the judge did not say she was harassed. The judge did not say she made a great point. The judge did not say this was an unsafe or hostile working environment. What the judge said is there's enough evidence to bring in the issue to the jury. Furthermore, the judge says there are triable issues with respect. Okay, this is my favorite part of the lawsuit. I've been waiting to get to this part. There are also triable issues with respect to whether the Wayfarer parties took any adverse employment action against Lively. Remember, she doesn't have to be an employee at all to suffer an adverse employment action, and she doesn't have to be employed by them. Indeed, and in fact, the court already decided she ain't an employee, but that doesn't mean she can't have still suffered an adverse employment action. And if you don't understand how that could be, you got to rewind and go watch that part. The main way in which Lively believes the Wayfarer parties retaliated against her is by concocting and executing a multi-tiered social media plan to destroy her reputation. That allegation represents the crux of her case. Okay, remember? The crux of her case, I've been telling y'all since like early 2025, this was the crux of the case. It's not specifically retaliation, although that's the legal mechanism. It's not harassment. It's not defamation. It's not false light, not intentional infliction of emotional distress or negligent. It's none of that. The crux and the heart of this case has always been and is still today the smear campaign. Factual background. In May 2024, after Ryan Reynolds blocked Justin Baldoni on social media, Justin Baldoni worried that Blake Lively might do the same, to plant seeds and give crumbs so fans would go digging. Okay, so what happened here? Blake Lively's husband blocked Justin Baldoni. Now, early on, I had a theory, a speculation conspiracy theory that Blake Lively and Justin Baldoni got a little too close to each other for Ryan Reynolds' comfort. And he was the one behind all this because, I mean, Justin Baldoni's way more attractive than Ryan Reynolds. Like, let's not joke around. And he's all kissing and hugging and getting hot and heavy and also beating up Blake Lively, like, as a character, the characters. And I could see, Ryan Reynolds being like, you spending so much time with him. They have this young baby. Again, that's a conspiracy theory. I don't know if that's true. I just made it up. Okay. I haven't even really thought about it again, but Ryan Reynolds, the first one to make a move here. He blocked Justin Baldoni. And when he did that, Baldoni was worried that Blake Lively might do the same thing. And it would be in order to plant seeds and give crumbs so fans would go digging like an Easter egg. He therefore asked his publicist, Jennifer Abel, to formulate a real plan in case that happened. So in case Blake Lively started to plant seeds for fans to go digging. He wanted this plan to be set in place so that he could feel at ease. Baldoni's concerns continued to escalate after other cast members appeared at a June 15, 2024 book bonanza without him. 2 days later, Justin Baldoni and Jennifer Abel had an hour-long call on the phone in which he asked for recommendations for attorneys. All right. Oh, okay. Did he get recommended Brian Friedman? Asked for recommendations for attorneys. Jamie Heath also asked Mitz Toskovich, Wayfair's vice president of operations, to start compiling a timeline document regarding all the alleged incidents. That was in May 2024. Now, 2 months later, July 2024, Blake Lively informed Sony she was not going to be appearing in press with Justin Baldoni. Tara Hanks, the president of Wayfarer, asked Wayfarer's publicist at the time, whose name was Stephanie Jones, for recommendations for a crisis communications team. And this is where all hell really started to break loose. Jennifer Abel, she worked for Stephanie Jones. She also asked Heath to share with her the legal letter that was sent by Blake Lively. Per their conversation, they're going to go through point by point and draft context surrounding each situation. We can then flag what we are missing. That would be helpful to arm us in the case we need to refute any of the claims. Abel, though, recommended this woman, Melissa Nathan from TAG, for the crisis communication role. So they were getting ready to do crisis communication. Okay. Blake Lively told Sony she wasn't doing press. The president of Wayfarer then asked the publicist, Stephanie Jones, also working for her was Jennifer Abel, for recommendations for a crisis communication team. Abel also asked Jamie Heath, the CEO of Wayfair, to share with her the legal letter. They were all going to start drafting, getting point by point responses to the allegations that they were preparing to go to a PR war. Abel recommended Melissa Nathan. Now, there was beef, there was drama, there was tea. Okay. Stephanie Jones and Melissa Nathan already had beef. They don't like each other. Stephanie Jones felt like Melissa Nathan was coming in to roost in her nest. She said, no, I don't want her to come on here. I'm going to advise no on Melissa Nathan. But her own employee, Jennifer Abel, kind of went behind her back and still brought on this Melissa Nathan and TAG for the crisis communication role. Melissa Nathan and her company, TAG, Vice President Catherine Case, met with the high ups at Wayfarer for an introductory call, during which Wayfarer provided details regarding the protections letter. Now, to remind you, what is the protections letter? The protections letter was those 17 things that Blake Lively demanded, the protections she wanted. The vice president of TAG, so the crisis communication lady, one of them, her notes from the meeting state that Wayfarer is not going to fire offensive bullets, but they wanted to have a strategy. After the call, Wayfarer engaged TAG. So they did an introductory call and they did decide to go with TAG, Melissa Nathan's company, to ensure that they were protected against any negative attacks. So they were just going on the defensive. At that point, July 2024. At the very end of that month, July 31st, 2024, Jennifer Abel texted the CEO of Wayfarer that confidentially, she was out to dinner with a friend of 12 years who writes for the following, okay? People Magazine, Fox News, In Touch, Us Weekly. And this writer is fully briefed on the situation and is armed and ready. Armed and ready. Look, this is battle. This is war terminology. Armed means you have weapons. Hey, Jennifer Abel said, I'm out to dinner. I'm just telling you confidentially, I'm out to dinner with a friend of 12 plus years. She writes for People Magazine, Fox News, In Touch, Us Weekly, and she is fully briefed and armed and ready to take the story of Blake weaponizing feminism to any of her outlets the minute we give her the green light. She hates Blake. She's heard the story before and she will do anything for us. Just FYI. Okay, so this is what Jennifer Abel was texting. All right. The next day, August 1st, 2024, TAG discussed drafting. Now, again, TAG is kind of like a brought on firm. This is not Stephanie Jones Works. It's two crisis management firms involved right now. One's just a run-of-the-mill PR firm that's Jones Works. Stephanie Jones works. That's where Jennifer Abel works. And then the other one's like a crisis communication. Like, oh, we got a crisis. We got to bring them on. That's TAG and Melissa Nathan and Katie Case and them. On August 1st, 2024, TAG discussed drafting a scenario document in anticipation of an inevitable story from Blake Lively's team. Okay, so they wanted a scenario document. They wanted to be able to de-sensationalize Lively's story by teeing up a friendly to run the day of or right after the premiere, someone who was covering the overall film. Baldoni saying something along the lines of, me and Blake had our differences, but I still respect her. So we at least set the stage and then can give the rest on background to reporters. So when the hit piece runs, it's not as big of a shock. Okay, so they were trying to steal the thunder. That was the first plan. Get Justin Baldoni's PR team out there telling Us Weekly, People Magazine, In Touch, and the rest. Yeah, we had some disagreements on set, but it's all love. They wanted that to come from Justin's side. So whenever the hit piece against Justin came out, I was like, oh yeah, we already knew that. That's called stealing thunder. They're calling it a friendly. Melissa Nathan's whatever she is over there, Katie Case working at Tag, sent Wayfarer a scenario planning document the next day. In it, Tag recommended certain messaging points emphasizing both Baldoni's stellar reputation, including his history of activism and advocacy of and for women in Hollywood, and also emphasizing Blake's less than favorable reputation in the industry. So they wanted to compare in the scenario planning document that Justin's team prepared. They wanted to focus on Justin's stellar reputation, and they wanted to focus and compare and contrast that with Blake's less than favorable reputation. The document also suggested that Tag explore planting stories. Okay, now we're starting to get so far so good, right? So far based on the law as we've read it, and also just based on my gut check. If somebody's about to start writing stories about you, and you're like, oh, let's put a thing out saying, yeah, we've had disagreements in the past, but it's all love, and I'm so glad I got to work with her. Okay, fine. That doesn't seem like retaliation to me if I'm on the jury. But let's see. The document also suggested, exploring planting stories about the weaponization of feminism and how people in Lively's circle, like Taylor Swift, have been accused of utilizing these tactics to bully into getting what they want. Melissa Nathan has testified that the document was not an approved action plan, but only a preliminary document for purposes of scenario planning, with each suggestion being only a possibility. Minutes after receiving the document, Justin Baldoni texted Jennifer Abel, who again does not work for Tag. She brought Tag on, but so Justin's kind of going to Jennifer being like, I don't really like these people. I hired them, but I'm not in love with their plan. He said, I'm not really sure I'm feeling the protection that I felt on the call. Jennifer Abel, she's a little gossiper. Okay. She then starts typing away on her phone to Melissa Nathan, who she had brought on. She had brought Tag on as the crisis communication. Now, remember, this is not her boss. Her boss is Stephanie Jones. Stephanie Jones did not want Melissa Nathan even sniffing around this case. But Abel is undermining her boss, and according to these filings, and working with Melissa Nathan. And remember, her client is supposed to be Justin Baldoni. She goes to Melissa Nathan. She's like, you're going to have to do something more. Justin is not happy. She said, I'm going to confidentially send you something he's texting me and Jamie on the side just to arm you before this call. I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He wants to feel like she, meaning Blake Lively, can be buried. Melissa Nathan responded to this other PR girl, Jennifer Abel, and said, of course. But when we send over documents, we can't send over all the work we'll do or could do, because that could get us in a lot of trouble. Okay? We can't put it in writing what we're able and capable of doing, because that could get us in a lot of trouble. We can't write it down to him. We can't write, we will destroy her. Jennifer Abel said, yeah, of course not. But I told him that's the point of talking through. Melissa Nathan pipes back. He has to look at it as an information document for us to be armed with. That's all. Imagine if a document saying all the things that he wants ends up in the wrong hands. Well, it has now. We can bury anyone, but I can't write that to him. I'll be very tough. Melissa Nathan also sent an agenda for the meeting to Jennifer Abel for the upcoming call with Justin Baldoni. And it included discussing a more aggressive way to get ahead of this. On August 4th, 2024, Jennifer Abel messaged Melissa Nathan again that she was having reckless thoughts of wanting to plant pieces about how horrible Blake Lively is to work with. She wanted to plant pieces. Melissa Nathan responded, same. She shared that she already had spoken off the record to the editor of the Daily Mail because she's my friend and she's ready when we are. So now we have two different people who have, in writing, been willing to exploit their personal contacts and their personal relationships for this PR smear campaign. Now we're talking about Abel saying that, Melissa Nathan saying that she knows somebody at the Daily Mail. Now, remember, what did we talk about hours ago at the beginning of this live stream? Who else does Melissa Nathan know? Her sister, Sarah Nathan, who works for Page Six at New York Post. Baldoni's talent agent wrote in a message that same day, Justin's crisis team was ready for a war with Blake Lively. Okay. A war. His talent manager. We're ready for a war. We have all kinds of garbage on her. Okay. The next day, Melissa Nathan from Tag shared with Jamie Heath and Jennifer Abel 2 quotes from, quote, digital teams that Tag uses to get the best results. Okay, so she had 2 digital teams and they gave financial quotes. One was $175,000 for 3 to 4 month period and included website to discuss, full Reddit, full social account takedowns, full social crisis team on hand for anything, engage with audiences in the right way, start threads of theories to discuss. This is the way to be fully 100% protected. The second quote was $25,000 per month. So this was $175,000 for 3 to 4. This was $25,000 per month, minimum 3 months, so minimum $75,000. As needed to seed, same as above. This will be for the creation of social fan engagement. Creation of social fan engagement to go back and forth with any negative accounts, helping to change the narrative and stay on track. So this is manufacturing a narrative that was not already existing. This is very important. Melissa Nathan added, most importantly, the work will be untraceable. She explained that there was a lot more to both of these quotes, but that it would be easier to discuss via phone in terms of capabilities, because she already said we can't write it down. We can't say what we're capable of. But she was going to talk about her personal experiences in and out of crisis scenarios. Melissa Nathan was at this point in touch with none other than crisis communication coach, wellness agreement coordinator, possible CIA operative. I mean, is this guy another Harvey Pasternak? The world may never know. I don't know. I certainly don't. Never met him. Don't intend to. But at this point, Nathan was in touch with Jed Wallace and his company called Street Relations. Why were they in touch? Well, because they had previously worked together. Melissa Nathan and Tag. They had both worked together, I think, on a Paramount project. This is when clients required social or digital remediation. On August 6, 2024, the movie premiered. Baldoni and Lively did not appear on the red carpet together. A Tag intern flagged a social media comment suggesting Lively and Baldoni had not appeared in PR together. This makes me wonder how many of my comments have been flagged by people. Oh God, they got a YouTuber. They got a YouTuber saying negative stuff. Just in general, not in this case. Part of it is they didn't want to romanticize Lily and Ryle by having them do a ton of PR together. And another comment said that Baldoni was traveling with family. Case replied, okay, the comments are working. Excellent. That's all us. Okay, so she's saying it. The comments are working. Excellent. That's all us. So did they have bots? Did they have trolls? Did they have AI, LLMs? I mean, what was going really on here? At the premiere after party, Sarowitz had a conversation with Baldoni and Wayfarer's agent, Danny Greenberg, which Greenberg subsequently reported to Giannetti. I am a little concerned about Steve Sarowitz. He was really aggressive when I spoke to him. I have been texting Jamie to make sure he is managed. Yes, of course. We love the money changers managing everything and everyone. And to make sure he speaks with me before doing anything nuclear, Greenberg sent a separate text saying that he had to dial down the billionaire at a premiere who was ready for serious battle. The day after the premiere, Melissa Nathan and Jennifer Abel agreed that Wayfarer really needed to put out the social combat plan into motion. Of course, they think that they need money. They want money. Do that social combat plan so we can get paid. Cha-ching, cha-ching. Okay. Nathan would call to get Jamie Heath the green light. The Wayfarer people then sent Jamie Heath and Jennifer Abel an email with the subject line, social digital mitigation remediation, in which she provided the specifics. Okay, the specifics regarding the work the digital, quote, team could focus on. Okay, what was the work that what was the specifics? Including boosting search engine optimization efforts, updating the new content to enforce SEO efforts, monitoring, and directly influencing forums. This right here, I think should be criminal. I do not think, look, you should be allowed to go and tell, oh, an anonymous source told People Magazine, an anonymous source told In Touch, someone close to the parties. Fine. Fine. What, in my opinion, you should absolutely not be able to do, I should think it should be against the freaking law, to create fake accounts and fake engagement. That I do not think should be allowed, because it's like lying. It's like totally misleading, and it makes it look like it's like a general consensus of the public when it's not. Also, this, I will be very clear and honest, is one of the instances where I am personally biased, because I have been affected by these online paid for social media smear campaigns. You can't say, still to this day, can't say nothing nice about me on Reddit. Anytime somebody says something about me on Reddit that's nice, instantly it gets all these thumbs down. It's almost like it's a bot, almost like there's a program written into Reddit. I have been the subject, a victim. I've been the victim of these SEO campaigns. I've been a victim of fake liars coming out and filing fake bullshit in court. So me personally, I think it should be illegal. They want to monitor and directly influence forums against that are working against Justin Wayfarer to adjust, aka change the narrative in real time, collate assets and background to working collate assets. They have assets. That's like YouTubers. Hello. They're assets. They're YouTubers. They know. They're social media commentary channels. They know. The relationships they have with Daily Mail, In Touch, Us Weekly, People Magazine, Page 6, echoing Nathan's earlier statements. The tag lady Case added that the integral part here is to execute all without fingerprints. So they're sneaky. They are sneaky with it, almost as if they know something is actually very wrong with it. Almost as if they know they could get in a lot of, quote, trouble if they did it. Leveraging relationships with Discord. Oh, put a 3 in the chat if you know I don't have a Discord. Reddit, relationships with Discord, Reddit, X, Instagram, TikTok, YouTube, etc., to expose behavior of Blake and other parties, both current and past, and engage directly with communities to adjust or influence conversations taking place in real time. So to manipulate the public with lies or with truth, but to manipulate the public, to change what the public is thinking. This is sinister. This is the heart and soul of this case, and this case, just as I predicted back in 2024, 2025, is going to be the one, if it hasn't already, to show to people just how fake everything really is. Yes, Reddit, yes, X, yes, Instagram, yes, all of it. It's fake. All these accounts, all these social media accounts that do nothing and make no videos for months and months and months, and all of a sudden come back with a new Blake Lively video twice a day. There's a lot that applies to. I have so many conspiracy theories. I'm keeping myself in the moment. What else? These are the specifics. They want to utilize CTR manipulation and contextual links to push up positive PR to change subject matter opinion on the first page of Google. This isn't so bad to me, because pushing positive PR is not the same as pushing negative against Blake, and you'll see why in the analysis we get to. The next one was working to remove links that are harmful to Wayfarer, Justin, and the narrative. Okay, so this, how many times do I have a video copyright struck that's like 3, 7, 12, 11, 18 months old is all the freaking time? And I think it's these PR, campaigns. Working to remove links that are harmful to Wayfarer Studios. The next one is properly and strategically monitoring damaging Reddit, subreddits, X, Discord, including threads related to concerning opposition, and manage the narrative. So they don't even it's not good enough for them to just put out a positive narrative. They want to bury somebody. They want to destroy somebody, and not just Blake. They want to destroy any opposing viewpoint. They want to destroy our freedom of speech. They want to take down things that people say that are just simply opposing Justin Baldoni. They're not just saying, oh, pushing positive to the front page, which I already said I think is totally fine. I don't like Discord, and I don't like it because some missing frontal lobe freaks, some lunatics, created a Discord supposedly for me, which I never gave them permission to do. I definitely never told them to do it. And they called it That Surprise Army. And they were in there collecting people's data. I never went in there. Never went in there. And as soon as I kind of got wind of it, I disclaimed it. I said, don't go in there. That's not my Discord. But they were in there basically, starting all kind of rumors and stuff. And they did not harm me really at that point with the Discord specifically. They wanted to. They wanted to. And I think they were hired. I think they were hired as part of a PR campaign just like this. I think they were put out to start harmful narratives about me. They were supposedly my fans. I had never freaking spoken to them, never met them, never saw them in real life. And they started wreaking havoc. These people started going to places and almost like hunting people down. I think that they should have been criminally prosecuted for it. I mean, they're innocent until proven guilty. But they also, one of them went on, or two of them went on an HBO hit piece documentary about me. It was like full of lies, full of slander, full of bullshit, full of shit that never happened. And these people just made shit up. And so one of the things that I caught them doing, I caught wind of them doing in this Discord, because people did send me screenshots, were they were putting like people's personal information in there, and they were saying, let's all go to so-and-so's house. Like, they were basically trying, very obviously, to make it look like I was the leader of a group of clowns who, for the record, were flea infested and I would never associate with. Ew. And that's really the real reason they didn't like me, really, on a person, other than they were, in my opinion, I believe, hired, because I would never even sniff their way, because I don't want to have mildew in my sinuses. You know what I mean? So they had started this Discord called That Surprise Army, and they were wreaking havoc. They were acting like clowns, and I think they should be criminally prosecuted for it. That's my opinion. I think it was one of these things like this. I think it was an orchestrated PR campaign in connection with federal litigation, which kind of looks like this. That's just that's my opinion. But that's why I don't like Discord, because when stuff happens in a content creator's Discord or a social media influencer's Discord, the person whose name is on the Discord gets held accountable. You remember all that nasty stuff that was in Mr. Beast's Discord? He got held accountable. I don't have time to monitor Discord. I got shit to do. If y'all want to hear what I have to say, come to this channel and I'll say what I feel like saying, and nobody can make me say nothing that I don't feel like saying. And nothing that anybody says is a reflection of me at all. And I constantly have to disclaim that, because these lunatics, clowns, and degenerated freaks will try to blame me for any and everything that I didn't even do. Because why? Because I don't do anything actually wrong. So they have to pin other people's deranged, in my opinion, criminal, in my opinion, behavior on me. That didn't work. I keep winning lawsuits, by the way. Anyway, also, this can be done with legacy admin for each platform. As part of this, expert admins will also monitor. So they have admins. They have mods on Reddit. They have mods in probably Discords. Again, like I just said. Expert admins will also monitor and protect peripheral elements, like we'll keep your Wikipedia page safe. We will give you some fan pages and more to ensure threads and narratives are handled appropriately. We will actively sway the algorithm with one SEO charged hub site created and overseen by the team. Taking down full Reddit and all social accounts. They will take down your social account if you say something about their client. Do you see this? This is the heart of the case. Because it reaches beyond Blake freaking Lively. They're retaliating against people like me and you for simply saying something different to their campaign. And like I said at the beginning of this video, it's not just Justin Baldoni. Both sides of this had PR campaigns going on. So this is what I'm talking about. This is not acceptable. They're coming after us. They're coming after our freedom of speech. Getting our whole accounts taken down is like getting banished from the town square in 2025, 2026, even 2024 when this was going on. Absolutely unacceptable. And this is one of the reasons why I'm like, fuck Justin Bald, stupid ass, ugly ass, bony donny too. All of them that are doing this, they should have came out and said the truth. That's always going to be stronger than a lie. but they're so cuckified, they have to go ask these degenerated lunatics that don't do nothing but Adderall and gossip all day, in my opinion, to run their social media campaigns. These bitches are nuts. These bitches are crazy. That's who's running the social media. They're taking people's accounts down. They're taking people's whole voices away. Getting Reddit, getting full social media accounts removed. That shit is so beyond. That is beyond. And F all of them doing it. And you know what? I don't feel bad that your shit got took. I don't feel bad that your phone got took by your boss. This is all y'all had it coming. All of them had it coming. That's my opinion. This is sick. Organically, they're so freaking stupid. They call anything. Organically engaging with audiences in the quote right way. Okay, the right way means the way you're paying them to do. You see how that works? Starting threads with theories that the team approves of and asking questions that no longer place Wayfarer and Justin Baldoni on the back foot. Noting the uptick in social chatter, Tag's team case noted that the quote for these services had been raised to $30,000. So how do we know these people don't put the chatter out themselves whenever they're in the middle of negotiating? Oh, look, there's a rise in social chatter. We got to charge you another $5,000. How do we know they didn't put that chatter out with their proprietary, untraceable, fingerprintless? You see how it could turn into a racket real quick? Get extra $5,000 if we just start making people do social chatter. Now, maybe that didn't happen, but it's questions that I wonder. The same day, there was an uptick in social chatter, which gives me, put a 4 in the chat if you think that that's not unreasonable. You think it's a reasonable speculation that maybe they did the uptick in social chatter to try to secure this $30,000 for 1 month? And that's not nothing. That's a lot of money. And on the same day of the uptick in social chatter and the raise in the quote, in walks Jed Wallace. Lady at Tag introduced Jennifer A. Bell to Jed Wallace in an email. Jed and his team are absolute magicians. I did highlight that word. I thought that was important. Jed, hey Jed, Wayfarer would like to move forward ASAP with social digital mitigation and remediation, aka manipulating the internet into thinking that Justin Baldoni don't have no criticism. Is that an accurate depiction of what we just read or no? You tell me. Now, they call it social digital mitigation remediation, but that's just, they call anything. That same day, Melissa Nathan connected Jamie Heath and Jed Wallace. The next day. That next day, another person from Tag, first it was Case, the worker at Tag, introduced Jennifer A. Bell, who was also working at Jonesworks, and Jed Wallace. So the point person for Stephanie Jones, the point person, Jennifer A. Bell, she meets Jed Wallace via email the same day that there was an uptick in social chatter and a raise on the increase on the price. The same exact day, Jed Wallace enters the mix. And the very next day, Jed Wallace is pushed even higher up the food chain by connecting him with the CEO of Wayfarer, Jamie Heath. Hey, Jamie, please meet Jed, who will be having his team assist on all social activity based off our own conversations, as well as their digital plan you are in receipt of. Jed and team has worked on some of the most monumental behind the scenes projects globally. And I'm extremely happy to make this intro between you both. Jed Wallace responded, Jed Wallace responded to Jamie Heath and said, this is our wheelhouse and have it prioritized across all platform-specific specialists working for me. So he comes with an arsenal of specialists. My team is and has been in full throttle mode on our Wayfarer focus. After that, the Wayfarer parties made multiple references to Jed Wallace and the work he was doing on their behalf. For example, in response to A simple content creator posting that Justin Baldoni had exploited the struggles of individuals facing terminal illness for his own gain. Tag people told Jennifer Abel that they had flagged the creator to Jed. So does Jed sick like a bunch of haters on creators? I flagged that person to Jed and his team for more serious action on the social side. What the hell is he doing? And have I been a target of Jed Wallace? I mean, the webs I've made make me wonder very seriously. On another occasion, this lady from Tag circulated a social media comment saying, Daily Mail broke a story saying Blake called Justin abusive. I don't buy it. I think it's a way for her to get more control and attention of the movie. Thank the Lord for Jed, said the Tag lady. Case, likewise, the Tag lady likewise stated, thank the Lord for social and digital mitigation with respect to social media comment that it feels like certain people's PR team got ahead and leaked the story to the Daily Mail to justify them trying to take over the film. Shortly thereafter, they wondered whether they had Jed suppress the link to the Daily Mail article because she couldn't even find that story. So Jed Wallace can suppress links to real news stories. We're not just talking about Reddit. I'm just reading from a lawsuit. I don't know what the hell Jed Wallace can do. I don't even know if this ghost is real. Okay. But Jed can suppress links, not just to Reddit, not just to social media admins. He can suppress links to real news articles. She also remarked that there was extremely limited pickup on the Daily Mail and Page 6. What about Page 6? Why do we care about that? That's Melissa Nathan's sister works over there. Remember that? Sarah Nathan. We're going to get into that in a moment. Articles that they also had started to see a social shift due largely to Jed and his team. Their efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Do you start to see now how this judge thinks a jury might find some of this stuff retaliatory? Not that it is, not that it for sure is, but that there's enough dispute. A jury might, because this is so beyond the pale. Again, I want to remind you, there was a time, and it wasn't long ago, 2 years ago. People didn't know this is how this worked. People inside Hollywood, people who had dealt with it personally, but in the mainstream at the Thanksgiving table, at the couch eating, watching Survivor at night with your family, people had no idea that the articles that we read on the Daily Mail, In Touch, Us Weekly, hell, even CN freaking NBC, Chloe Malos does the same stuff, in my opinion. They talk to publicists. They talk to PR people. They talk to crisis managers. Where does TMZ get their stories from? People's publicists. But there was forever. This was not common knowledge. This was not common knowledge. But because of this lawsuit, or largely because of this lawsuit. Yes. I know a couple lives ago, you read the transcript, but have you actually heard the audio of Jed Wallace talking about smearing that ghost girl? It literally gave me chills. You can hear the demons. Yes, I have heard it. And it disgusts me that a grown man could be that interested in absolutely obliterating a woman with sexual lies, saying she was a S trafficker, and this grown man wanted to make that lie up about a woman. That blew my mind. Absolute magicians. You saw that, huh? The record, the judge goes on, reveals other similar incidents. Like on August 10th, 2024, Jennifer Abel reached out to the Tag team saying it would be great for the digital team to boost a particular video in any way possible. I want to know. I'm writing it down. I want to know which particular video. What page are we on here? Particular video. I've now been on here for 3.5 hours. I just want to let y'all know this channel is not yet monetized. I am working fastidiously on it every single day. But if you're finding this to be useful or helpful, you are more than welcome to drop a Cash App or a PayPal. I would really, really appreciate it. Or just go show some love to the video I made on Surprise Witness. What page is this? 123. We've been through 123 pages today. Okay, thank you. The record reveals other similar incidents. August 10th, they wanted the digital team to boost a particular video. I want to know which video was it. Was it Kirsty Flaw? Because I got my own bone to pick with that bitch. Yes, I do. Yes, I do. Because remember that HBO hit piece I was talking about, full of lies? Full of absolute slanderous and defamatory lies about me and people who have never met me talking delusionally on that documentary as if they knew me and ever met me in their life. You remember that one? Well, guess who provided some free Britney footage of her very own for the hit piece? It was a hit piece against me. I mean, that's absolutely undisputed. It was a hit piece against me. It was supposed to make me look absolutely batshit crazy insane. And it almost did because they lied to lie. They didn't make up lies. Guess who gave the footage for the hit piece of the Free Britney rally? Guess who gave the footage? Kirsty Flaw. Mm-hmm. You think that's a coincidence? I don't believe in coincidences. The Curious Case of Bam Margera? You mean the very same Bam Margera? That was the title of the hit piece. The very same Bam Margera that Jed Wallace had personal contacts with. The very same Bam Margera. Bam Margera that was under a wellness agreement and Jed freaking Wallace of Street Relations watched him take his medication every day. The same one. So the Curious Case of Bam Margera that aired on HBO Max had Kirsty Flaw just happen to have some archive footage sitting there to use in a hit piece against me. Doesn't that sound like kind of exactly what her role in the Blake Lively case was? She just happened to have this archive footage of an interview she did with Blake Lively, and that was the organic video that made everybody dislike Blake Lively. I'll be honest with you, when I watched it, I didn't think Blake Lively looked too good either. But who was sitting on that interview and who released it? And more so, which particular video on specifically August 10th, 2024 was being asked to be boosted? Case from Tag responded, "We'll flag to them." That means Jed. We'll flag to Jed. Abel added that she liked a video. So even themselves, they're liking these videos regarding Lively's problematic on-set behavior, and it's now getting some viral attention. So they're making stuff go viral, but then they want to call it organic. In the same message thread, Abel shared another link in case Digital has an idea of how to amplify. Digital is Jed. We'll share this as well. At the very least, ask for engagement in the comments. Baldoni also, the next few days later, sent links to 2 TikToks. One by an individual who spoke positively about her experience working with Justin, and another which criticized Lively's marketing of the film as insensitive. Abel confirmed, "We have this, and this is what the Digital team is amplifying." Okay, we are amplifying it. We are amplifying this. That's not organic if it's being amplified. The next day, Melissa Nathan circulated a screenshot of a Daily Mail article. Remember, Melissa Nathan was the one who said she had the contacts of the Daily Mail. It was called Hollywood Villain. It branded Blake Lively a mean girl in light of the 2016 interview with journalist Kirsty Flaw. Remember her? She provided the... Is that kind of random to you? I never heard of this damn lady in my life. Yes, she's a very highly followed YouTuber at this point. Yes, she's a journalist. Put a 5 in the chat if you find it to be a little bit too coincidental that Kirsty Flaw is the one that HBO had, of all the thousands, I'm talking thousands of people who have HD, high def, Free Britney footage, and they got it from Kirsty Flaw on a hit piece that was supposed to make me look bad. Obviously was supposed to make me look bad because it was full of lies, and the people that put the lies out knew that it wasn't true. They also didn't bother to mention that I had won every single thing in the courts against Lima and against these people. They were like, she has outstanding lawsuits against her too. Hopefully they get justice type of thing. It's like, bitch, I already won. The fuck? And Kirsty Flaw happened to be the person they credited with giving them free Britney footage. It's almost like it was like a PR company that disparages and defames people for money. I don't know if that's true, but it's like, what are the goddamn chances? Kirsty Flaw's 2016 interview just starts going viral. Maybe it's because It was amplified. Remember who it was that knew Daily Mail and had connection at Daily Mail? It was Melissa Nathan. So obviously, in my opinion, from reading this, Melissa Nathan is the one who amplified the Kirstie Flaw thing. Melissa Nathan is the one who brought Jed Wallace on. Jed Wallace has worked with Bam Margera. Do you see? Put a 5 in the chat. Put a 5 in the chat if I'm not crazy. C. Cal, Hanib, Only Lord, Latina Lucero, Kiara. Y'all don't think I'm crazy. Wendy don't think I'm crazy. Some of the people in the documentary even recanted. C. Cal, It's Only Catnip. I'm not crazy. Look, there's a bunch. There's a bunch. What are the chances? What are the chances? Kirstie Flaw has made quite a name for herself. She has gotten quite a few 100,000 or millions of views on this Blake Lively story. Is there perhaps a conflict of interest for her to have a certain perspective? Is she perhaps being amplified and getting more clicks and more views to have a certain perspective? Now, to be very clear, to be extremely fair to her, I might be schizophrenic and delusional, okay? She might have nothing to do with this. But to me, it's just, I put a pin in it. Don't worry, I remembered it. I'll say that. Anyway, so yeah, the Kirstie Flaw interview comes around, and if I'm allowed to be honest, this is my channel, I'm allowed to be honest, it was kind of off-putting how Blake Lively acted in that interview, yeah. But Kirstie Flaw was acting like a fucking weirdo too. Have you ever heard anybody congratulate someone's pregnancy by saying, "Congratulations on your little bump"? You mean the human I'm growing? I mean, fucking congratulations on my little bump? What the fuck kind of weird shit is that, really? I might have said, congratulations on your bump, bitch. The fuck? Anyway, I know y'all didn't like that. I know y'all don't agree with me on that. But look, I'm allowed to say my opinion. I think it was weird behaviors. And I don't think it was that weird for Blake to say, "Congrats on your bump." You could have just said, congratulations on your pregnancy. Like, that's the adult thing to say. "Congratulations on your little bump." And pointing. It's just fucking weird. Like, I found it to be strange. And I mean, it's easy to hold, celebrities and stuff to certain standards, because y'all don't really know how it really be feeling to like have every single thing about your body, your hair, your face, your this, your that, always commented on. I don't have any idea either. I might have been recognized about 5 times out in public, and every time I'm like, I mean, it's cool, but it's also like, oh God, did I do my makeup? Like, you're kind of like trying to be presentable. You're on a tour. She's pregnant. Imagine being pregnant on a freaking press tour. And look, that's her job. I don't feel that bad about it, but I'm just saying, like, Blake Lively is aggravating. She's not relatable. She probably is a bully and a mean girl. And I strongly believe, in my opinion, she tried to steal, in my opinion, Justin Baldoni's movie right out from under him. That's what I believe. But a lot of things can be true at once. I don't really think that Kirstie Flaw thing was as big of a deal as everybody was trying to make it seem. I just don't. That's my opinion. And I'm allowed to have it. And I mean, I guess I could change my mind, but that's what I believe. It's weird too. Maybe she was nervous. Yeah, I mean, it's weird. It's just strange. So all this, oh, poor Kirstie Flaw, like, well, maybe Kirstie Flaw needs to learn how to fucking act. What in the hell are you going to ask somebody? "Congratulations on your little bump." We don't talk like that, okay? And so if somebody said that to me, I'll probably be weirded out too. Like, on my little bump, can we personify, or just like maybe not comment on it at all, or just say congratulations? Like, how are you feeling? Like, I don't know, congratulations on your little bump. It was fucking weird. And I really do think that the fact that it was weird and it's not being highlighted and it's not being discussed has a lot to do with the fact that it was so amplified. Those early Kirstie Flaw videos got hundreds of thousands of views. They got amplified, and I'm wondering how. I also think it's very interesting that on this channel, I pretty much have like 400 to 500 people in the chat the whole time, usually. It hasn't even broke 300 today, and this is the biggest story in the headlines. Am I being de-amplified? Maybe not, girl. Maybe I'm schizophrenic, but make sure to drop a donation at the Cash App if you can. Okay. It was very weird. She wanted his movie. Ryan pushed her. The movie isn't even good. I can't imagine a part 2. Okay. I do have to get off of here in about 20 minutes. So I want to get to the other things I wanted to say. A tag employee responded, OMG, this is amazing. We should send to Jed, right? On August 18th, Baldoni asked Tag to boost 2 TikToks depicting Baldoni positively, and one in which the creator explains that she's flabbergasted with the huge audience Blake Lively has and all the press interviews she had and doesn't want to talk about DV. Abel responded, yes, definitely. Let's boost these vids, I guess including Kirsty Flaws. We'll let digital know. The same day, Justin noted seeing some Instagram comments on random posts defending him by people who are private with no followers and they feel like bots, probably because they were. Stupid. Like, oh, it looks like bots. It probably was bots. Nathan responded, I can fully confirm we do not have bots. This is not what we do. Bots look fake to anyone. The other team is doing something very specific in terms of what they do. I know Jamie and Jed connected on this. Bots and fan accounts also run pretty organically by now with the AI platforms and Google Analytics itself. But there is no bot army. That is a myth these days. She is smoking crack or a liar, in my opinion. Maybe she bumped her head, or maybe she's right. But I have reason to believe there are absolutely bot armies. Any digital team these days is far more intelligent than to utilize something so obvious. Then why do bot armies still get used, stupid? Lively has also submitted expert reports that support her allegations that there actually was an online campaign to manipulate public opinion and discussion against her. There's a professor, Aaron Collada, a professor of computer science at Tulane. I wonder if he's related to Felicia Collada. Reviewed the posts and platforms discussed in the Wayfair party's text messages and found an indicia of artificial content manipulation on both TikTok and guess where else? Reddit. Among other things, Professor Collada calculated the proportion of likes on the top comment of a social media post versus the total number of likes on the post as a whole. Researchers have found that this can act as a reliable signal of potentially manipulated activity. The professor found statistically significant and practically significant deviations in expected values. Okay, so there's a professor found some evidence of bot manipulation or artificial manipulation. The Wayfair party stated their campaign would be untraceable, but there were online markers of inauthenticity, suggesting a manipulation campaign. Now, I want y'all to remember what Miss Thing said, okay? Melissa Nathan. Okay, I want y'all to remember what Melissa Nathan said. She said, I can fully confirm we do not have bots. This is not what we do. Now, who is we? That could mean anybody. Is it just her? Bots look fake to anyone. The other team is doing something very specific. I can't put it in writing because I could get in a lot of trouble, but maybe you could talk to Jamie because Jed told him how it worked. Bots and fan accounts run organically by now with the AI platforms and Google Analytics. There is no bot army. That's a myth. I completely disagree, by the way. Any digital team these days is far more intelligent to utilize than to utilize something so obvious. Okay, any digital team these days is far more intelligent. Well, if they're not using bot armies and they're not using fan accounts and they're not using bots, what are they using? Well, it was accused in Blake Lively's filings that they were using, in part, for example, Melissa Nathan's sister, Sarah Nathan. And I was working, this is where this comes full circle. I was working recently on a BJ Investigates video that comes out in 12 minutes. And it's on the dark side of Hollywood mentorships, completely unrelated to anything having to do with Blake Lively, completely unrelated to anything having to do with Justin Baldoni, anything about Wayfarer, anything about BAM. Completely unrelated to anything. Guess who also wrote an article about Bam Margera that he had run away from rehab? Sarah Nathan. So she's, again, I don't know how much Melissa Nathan has to do with Sarah Nathan's articles, but I do know that Blake Lively accused Melissa Nathan of utilizing her position or her relationship with her sister to get certain bad stories run about Blake in Page 6 by her sister. And I was doing some research about Justin Bieber and Usher's mentor relationship. You know, Usher signed Justin Bieber. I showed y'all this. It's actually on the Blake Lively map. I showed y'all this. Oh no, it's on the Tana Mojo map. I showed y'all this already, you know, the Usher Justin Bieber mentorship. And he actually was the one person in the beginning, one of the people in the beginning who signed Justin Bieber to his first Usher, signed Justin Bieber. I have a video about this coming out and about, you know, what happens when these, you know, people who were kids, whenever they started being mentored, turn into adults. Eventually they want kind of like, okay, can I like live my own life without this guy breathing down my neck all the time? Well, I mean, I come across this article. Actually, the BJ Investigates editing production studio headquarters team of one person came across this article, but can you stop? This is an article written by Sarah Nathan, for example. Okay. The title of the article is Why Justin Bieber Turned Down Usher's Offer to Perform with Him at the Super Bowl. And I talk about this in my video. Usher asked Justin Bieber to be in the Super Bowl, but Justin wasn't feeling it. Before Sunday's event, Justin's longtime friendship with Usher sparked social media rumors that the two would team up on stage. So just after going through those 130 pages we just went through, we didn't finish the lawsuit. But don't questions start to rise up in your mind, like even as you're reading this, like, okay, just even though this has nothing to do with Blake Lively, Justin Baldoni, like it just reeks of the pattern we just kind of learned about from this judge. And most of that was undisputed facts, most of it. Before the event, Justin's longtime friendship sparked social media rumors. Hold on. Did someone start, amplify, or seed the social media rumors that then gave Page 6 the ability to link it, kind of like they were amplifying other people's videos on TikTok? Like, you know, what if Page 6 wanted to write this article, but for what? It's just too obvious that the PR companies are doing it. So now we have to go through this proxy and like have a fake online social media question start. Now, devil's advocate position, to be very and extremely fair, I was also wondering about the relationship between Justin and Usher at this time, because I would expect Justin to be going to perform in the Super Bowl with Usher. So I'm not a bot. I'm not part of nobody's paid program. And I was asking those questions on social media. So I'm not saying they were planted, but what I'm saying is, with an article written by Melissa Nathan's sister, let me just show y'all the proof that it was written by her. Look, by Sarah Nathan, published 2 days before Valentine's Day, 2024. It calls into question the credibility of the entire publication and certainly everything she writes. Can she just be sent a story and run it because her sister told her to? Before Sunday's event, Usher and the friendship with Usher and Justin Bieber sparked social media rumors that the two would team up on stage in front of the 65,000 strong crowd and a global audience of millions. Instead, oh, look how it makes Justin Bieber look kind of bad. A slightly worn out looking Bieber watched his one-time mentor's show from the comfort of a suite. He was at the Super Bowl, but he did not perform. They nodded along to the performance. A music industry source told us there's no bad blood. I swear, I covered this literally in my video. And when I covered it in my video that's coming out in 7 minutes, I had no idea. I didn't even remember which publication wrote this. But I was talking about media manipulation. Because recently the same thing happened with Justin and Usher. They got into it supposedly at a party, a Grammys after party with Beyonce and Jay-Z. With Beyonce and Jay-Z had hosted the party, and then Justin's there and Usher walks up to him and there's a kind of a fight that ensues. But then boom, 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 all these articles start coming out. DeBrat. There's no bad blood. It's over exaggerated. Anybody exaggerate anything kind of to make Usher look good, but also kind of makes Justin look not great. But it's like, there's no bad blood. I think that was an exact quote. This is not the first time there's no bad blood, PR, social media, control narration attempts, in my opinion, is what it looks like to me, has happened between specifically also Justin and Usher. And it just brings in Sarah Nathan, because it's like, if Sarah Nathan, and again, I don't know, did Sarah Nathan actually do what Blake Lively accused her of doing? But after reading 130 pages or whatever of that lawsuit, I'm just like, is anything we read real? Or maybe it is real, but is any of it actually trustworthy? This was back in the Super Bowl. Usher did his best to try to persuade Bieber. He wanted to create a moment that paid tribute to their history together. Oh, God. Look, that's them previously. The halftime star who reportedly wed his longtime love, Jennifer Gochiachia, in Vegas shortly after the show, had a large hand in the creation of the Bieber brand. So look, this article is think about who sent this information into Page Six. It's definitely somebody's PR. So was it Justin's PR, Usher's PR, somebody else's PR with interest? Usher helped Justin. He had a large hand in the creation of the Bieber brand. He helped him find worldwide fame. It kind of makes you kind of like, even subtly, it's manipulative, because it makes you be like, well, what a brat. Why doesn't he just do the Super Bowl then? Discovered by Scooter Braun. I covered that in my video coming up. And the pair duetted on Somebody to Love in 2010. In 2019, Bieber opened up about his struggles with anxiety. In 2022, he called off the remaining dates of his tour. And he also hired Lou Taylor that year, but he's since fired her. In addition to a painful rash, this Ramsay Hunt syndrome can cause facial paralysis, hearing loss. At the time, the musician wrote that the touring took a real toll on him. Not Corey Gamble? No, it's not. Earlier this month, he performed live for the first time in more than a year. This was in 2024, by the way, at Drake's History Club in Toronto, ahead of the NHL All-Star Weekend. In Vegas, Bieber was more than happy to soak in the weekend's atmosphere. This was the Super Bowl. He was seen at a Super Bowl party in Vegas. He jumped behind the DJ booth. He hung out with Travis Scott, Lou Taylor client. Don't forget how Lou Taylor could be tangentially related to all of this as well. She was involved in the Justin situation for a while. She was involved in helping sell his category. She was involved catalog. She was involved in Britney Spears' conservatorship. She was going to even try to be the conservator in the beginning, according to emails. Now, she's, said that those maybe aren't real, but look at the little Justin and the little Usher. Ahead of the halftime show, one fan wrote on X, who was that? Was that one of their bots? Is this possibly one of the ways they amplify certain X posts? Wrote on X that Bieber and Usher together could solve world hunger, end global warming, clean the oceans, and build villages. Again, think about the slant. It's a subtle manipulation. If only Justin would have. It's Justin's fault. Look how much Usher helped him. Usher really tried. He really tried to get Justin up there on the. It's like the whole thing is manipulative. Usher instead brought out guest stars Alicia Keys, her, along with Lil Jon, Ludacris, Jermaine Dupri, will.i.am. This was like the last real Super Bowl performance where they just had a bunch of different people on a full marching band and an army of dancers and Sin City showgirls. Another fan wrote, again, how do we even know these are real? Like, who is the fan? What do you mean? We're going with fans on Twitter instead of sources? You're Page Six. You're Melissa Nathan's sister. Look at that in context. Is Melissa Nathan maybe telling her sister which fan posts to amplify in her coverage? And Melissa Nathan also said that she had contacts at the Daily Mail. Is this what's really been going on this whole time? I argue and speculate and believe, in my opinion, yes. The whole time. Subtle manipulation. Oh, look, some users on X said it. Okay, but did Jed Wallace tweet it? Who tweeted it? Who's the user on X? Can we get somebody who with a name attached? A fan. Usher brought all those people on stage and not one of them was Justin Bieber. Despite some lackluster reviews for Usher's performance, He ripped his pants. Oh no, the zipper just don't go all the way up. Oh. Despite some lackluster reviews for Usher's performance, it was watched by over 30 million households, according to figures released on Monday. So there you have Melissa Nathan's sister writing a story about Justin and Usher. And again, it just came in the wild, completely unrelated to anything I was doing with Justin Baldoni, although there's two Justins here. Justin Baldoni, Lil Wayfair. It had nothing to do with any of that. She's a Page Six writer. Maybe she just think about it this way. How could somebody that works at Page Six even come across these stories if people aren't telling them? Sure, they probably have contacts they can reach out to. Hey, what's the deal with Justin and Usher? It came across my timeline in the wild. Okay, it's 420. My other video on Usher and Justin, including talking about that specific incident, is going to be premiering right this very second. If you stay where you are, you should be redirected. It's on BJ Investigates. And that's all I really had for this one. In the meantime, facts ain't defamation. Neither are opinions. Everybody's innocent until proven guilty. I don't know any of these people, and everything I just said is my opinion. Love you, mean it. Okay, bye.